For reasons mentioned in the judgment, the impugn order dated 18/4/2016 is set aside, and the prayer for impleading the Punjab National Bank as one of the defendants is allowed. However, the second impugn order dated 16/5/2016 second impugn order dated yes 16/5/2016 is upheld and is not interfered with, and the prayer for recalling the witness number 2 PW2 for purpose of cross examination is allowed. This civil revision petition is accordingly disposed of. Both.
Delivery of order item 3.
For reasons mentioned in the order, the petitioner is allowed to go on bail of ₹1 lakh with 2 sureties of like amount subject to certain conditions.
My lord, yesterday I have mentioned a matter for withdrawal.
Yes.
Unfortunately, it has not been listed. So it may can be taken today as unlisted.
Maybe later. I have to mention item number 38. I think that maybe fix suspect to it.
Item number 38.
Yes, sir.
What is your prayer?
Maybe a CD is not available.
Okay, you are on interim.
Yes, sir.
Heard Mr.
Sneo.
S. Neo, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor, who prays for allowing the petitioner to, who prays for some more time for production of the case diary. The prayer is allowed. When?
19th of August.
Let this case be listed again on 19th of August. The interim order shall continue till next date.
What's up this? Maybe little lordship, my lord, this BA bail application may be listed for hearing on the after tomorrow. Now he is, my lord, 192 days is now.
Not there.
Earlier date may be.
What was the last order?
Last order, lordship. 23/6/2025.
It has to be in the first week of
23/6/2025.
7th of August. 7th August.
This month.
No, it may not be possible. 7th August.
Hello, the item number 30, my lord. Case diary is also available. Lordship may kindly fix it at 2, my lord. Mr. Z. Kamar will appear in this case.
No, why at 2?
Mr. Z. Kamar is, my lord, in other court, my lord. So that is why, my lord.
No, you have to wait till for your turn.
Please, lordship. My lord, regarding item number 58, my lord, additional affidavit has been filed, my lord. My lord allowed to bring in.
Okay, bring the addition.
Hello.
May I please pay for a listing of a regular bail application? Earlier, lordship, this bail application was supposed to dispose of by the retired Justice M. Nandi, lordship. It was came up on 17 June, lordship, but
matter has not taken up by this retired justice.
29th July. 29th July.
Lordship, Friday, Lordship. See,
No.
he's behind the bar and he's
All are behind the bars. We, in this
more than 2 years.
29th, otherwise I will list it in August.
Village building.
May I appeal, Lordship? I beg to mention item number 39 Miller. As per information, Miller, learned print Miller, CD not received Miller.
Heard Mr. A.M. Ahmed, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor, who prays for some more time for producing the case diary. The prayer is allowed.
Why?
List this matter on 19th of August.
There is an interim.
The interim order shall continue till next date.
May it please, your Lordship. Lordship, I beg to mention for listing of a bail application. Lordship, it was last posted on 24th of June. Lordship, may this matter come up on Thursday or this Thursday or Friday, Lordship?
29th.
Lordship, God bless.
May I please, your Lordship, on bail petition, Lordship, last posted on 24th for 2025, Lordship.
28th.
Alright.
28th July.
God bless.
May I please, your Lordship, I beg to mention item number 29. Lordship, as for information, CD is not available, Lordship.
Heard Ms. M. Das, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, who prays for some more time for producing the case diary. Prayer is allowed. Let this matter be listed. 31 July.
I beg to mention a listing for a BA, Lordship, for motion. Any date next week, Lordship.
When have you filed?
Lordship, actually, we had filed before the vacation, but we had taken adjournment, Lordship. It was to be listed, but it has not been listed.
28th.
Right, Lordship.
May I please, your Lordship, I beg to mention item number 61, supply item. And the
Six.
agenda matter for the day.
61.
61, supply.
Okay, heard. What is your name? Heard Miss S. Fukan, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned counsel for the petitioner, has prayed for an adjournment on the ground of personal difficulty. Case diary is available? Okay, the prayer is allowed. When do you want?
Day after tomorrow.
No, 28th. Let this case be listed on 28th.
May I please, your Lordship? Your Lordship, I would like to mention item number 15, your Lordship. Item will be adjourned for the day, your Lordship. 15.
Why you are seeking adjournment?
Lordship, the engaged counsel for some personal difficulties of the engaged.
Heard, Mr. What is your name?
S. Rahman.
S. Rahman, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the petitioner. The prayer is allowed. Let this matter be listed on 28th.
I noted.
May I please, your Lordship? Lordship, I beg to mention for listing of BA, Lordship.
When have you filed?
Yesterday, Lordship.
It will come automatically. Wait for the...
Lordship, it's urgent matter, kindly.
Every bail is urgent. You have to wait for that period. If it does not get listed, then you make mention.
Okay.
May it please, your Lordship. Lordship, I beg to mention a bail application for listing which was filed yesterday. Why I make a mention? Because arising out of the same FIR, the another connected matter is fixed tomorrow before your Lordship. CD is already called for by your Lordship on 19th.
Okay.
Oblige me.
Lordship for listing one IJ in Article 313/2024, any date in it.
I in respect of?
NDPS commercial quantity and 2024.
No, it is in respect of bail or what? Why I?
Petitioner is in jail more than 1 year.
No, you are not briefed properly. What is the purpose of filing I?
Bail and suspension of sentences. He was.
So it is in it must be in respect of some appeal.
Appeal number
But
313.
then for appeal there is another coordinate bench, which is taken, which is senior to this court. You have to make mention before that court.
May I please, your Lordship? Lordship, I beg to mention a bail application for listing, Lordship. It is supposed to be listed after vacation, but
28th.
Or withdrawal item 4.
Why are you withdrawing?
as per instruction of my client.
Heard Mr. H. Ali, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant bail application. The prayer is allowed. This bail application is dismissed on withdrawal.
Okay.
Item 56 from supplementary list.
Or heard, Miss, what is your name? As Parveen, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant anticipatory bail application. The prayer is allowed. This anticipatory bail application is dismissed on withdrawal.
Motion be item 5.
Yes, Your Lordship. So this is an FIR affair is paid Lordship. 14 Lordship. Under section 22C.
Is pending investigation.
Lordship.
Yes,
And
Okay.
Lordship, my ground is that no section 47 and 48 is not.
Kesari would be required. Heard Mr. AMS Majumdar, learned counsel for the petitioner. Also heard Mr. KK Parashar. Call for the Kesari. List this matter. When?
301.
37.
Item 6.
My lord, here in this case, POSCO is there, my lord, notice not there, my lord.
Heard Mr. A. Asik, the learned counsel for the petitioner. Also heard Mr. KK Parashar, learned additional public prosecutor. Issue notice to the respondent number 2 in pursuant to the prevailing notification of the registry in this regard. The petitioner shall take steps for issuance of notice upon respondent number 2 by within 3 days from the date of this order, returnable on 31st of July 2025. Whether it is a charge sheeted case,
My lord, it is
whether
charge-sheeted case, but after charge-sheet, he filed bail application that was rejected. Therefore, my lord, he has no way but to appeal this court, my lord. Charge-sheeted case.
Order is not enough.
The order we have not annexed, but there's some statement.
okay. What is your ground?
My lord, ground is that, my lord, the FIR itself disclosed that
Whether trial has begun?
the trial, charge-sheeted case, there is, I have no exact instruction, but trial maybe.
Okay, let us see.
Malat, otherwise, Malat, to bring the scan copy that.
We will not bring scan copy.
Then only.
We will issue notice and wait for,
My lord.
let this case be listed
Right.
on 31st of July.
My lord. Develop list.
Item 7.
May I please? This petitioner is custody since 22/7/25, my lord. 42 behind the bars, maximum period is 60 days, my lord. FIR at page 21, my lord. On the basis of the one Mustafa was initially apprehended, my lord. Page 21 is the FIR, my lord. I have not implicated in the FIR, my lord. Subsequently, I have been shown arrest in this case, my lord.
Kesari would be required.
My lord, already this Mustafa is already been granted bail. I am in 42 bail. He is the main accused, my lord. I am not named in the FIR. This Mustafa.
No, unless we will fix short date. Your role, what is your role?
My lord, the role is that I am only, that the forwarding report itself says that I have only aided Mustafa to procure, my lord, this card. Mustafa has been granted bail, and originally it was bailable, my lord, nature. Subsequently,
When can you bring the case diary? Short date.
Yes, yes, my lord, 29, my lord.
29. Heard Mr. A.M. Bora, Learned Senior Counsel, assisted by Mr. V.A. Chaudhary, Learned Counsel for the petitioner. Also heard Mr. K.K. Parashar. Call for the case diary. Let this matter be listed on 29th of July.
All right. Item 8.
Well, in this case, CD available along with, I think, 40 and 41, 42. 41, 40 and 41. Aman Sharma and Hassan also, Hassan that's. Now we have item number 40, CD maybe, so maybe taken along with the item number 40.
Then we'll take it up along with item number 40.
Nine.
Wait, please, Your Lordship. My lord, the Lordship will find the FIR at page 10 and the relevant portion that starts from page 13. And the main contention is at page 14, my lord. The facts of the case is that, my lord, certain articles have been seized from Shankar Soikia, from the residence of Shankar Soikia. And, my lord, only allegation against me, I am not named in the FIR, that I aided Shankar Soikia in traveling to some other place, from the place of occurrence. My lord, I am a driver of, professional driver, and I assist, the allegation is only assisting him.
What is your name?
My lord, my name is Vicky Ali, and my lord, I am behind the bar since 22/7/2025. My lord, already 85 days have been gone by, and my lord, the main accused, Shankar Jyoti Soikia and Pranami Dotto, they were given interim protection by this Honorable Court, and Honorable Court directed them to appear before the IO.
Interim protection.
Yes.
Where is the order?
Order, Your Lordship will find at page 24, Annexure 3, 25/6/2025.
On what ground interim
My lord,
protection?
the facts of the case relating to Shankar Jyoti Soikia's application is that he is a drug addict, my lord. Certain amount has been found from him, 1.3 grams of heroin and buffron tablets, which have been used by him for the purpose of de-addiction that has been prescribed to him by the doctor. So that medical.
Why your prayer was rejected by the trial court?
Trial court, my lord, kindly see the ground shown by the trial court is not justifiable. As your lordship will find at page 27. Page 27, kindly see, my lord, the first paragraph. It is submitted by the learned prosecution that as of now, the ingredients of 27A are directly not available. In such situation, I am of the considered view that the rigors of section 37 may not yet be applicable to the present accused. In spite of that, my application was rejected. I am behind the bar for 85 days, my lord. And all other accused persons, my lord, they are free.
How much is the contraband recovered in this case?
My lord, your lordship will find.
Why 22C is there?
My lord, may kindly have a look at page 14. The description of seizure items. Page 14. At the bottom.
Yes.
Page 14, Lord. It says suspected heroin, one packet weighted 1.30 gram. It's a small quantity. Now, the second article that is not scheduled tablet, scheduled substance, 3 and 4, this buprenorphine tablets, which has been prescribed by the GMC doctors to the petitioner, that has been recovered from his residence. That is taken by him for de-addiction. And admittedly, he is a drug addict.
Which police station is involved?
Morioni police station.
Morioni. When can you produce the case diary? Because without perusing the case diary, we don't know your role.
The other case, the interim order in which this honorable court passed the interim order, that is fixed on day after tomorrow.
Case diary is called for.
Yes.
Then we also fix it day after tomorrow.
Case number, that case number.
Heard Mr.
M. Chaudhary.
M. Chaudhary, learned counsel for the petitioner. Also heard Mr. K.K. Das. Learned counsel for the petitioner has submitted that in respect of bail application filed by the co-accused, in this case diary has been called for by a coordinate bench of this case in bail application number 1121/2025.
It's AB, not bail.
In AB case number 1125/2025. Hence, he prays for allowing the present
1121.
Then this matter should also go to that court.
That could. Let the city.
The only thing is that, these prime accused persons who have been named in the FIR, they have already appeared. Police has got their statements recorded, and they have been enlarged on bail as per direction of the.
But interim order not final.
And this prays for listing this bail application along with the said case. The prayer is about list this matter along with AB case number 1121/2025 on 24th of July. Let the case diary be called for in this case also. 24.
No, item 10 will be taken up with item 34 because case diary is available there. Yes, sir.
Okay.
Item 11.
May I please, Your Lordship? Lordship, the petitioner was arrested by the crime branch, Lordship.
Crime branch. Two.
Lordship, the other accused.
34.
Yes.
Okay, we'll take it up. Case.
Item 12.
Please, Lordship. Lordship, the accused is arrested under section 61(2)(a), 329, 3811 and 3 of ENS along with section 25(1)(a) of the Arms Act, Lordship.
We'll call for the case diary.
My lord.
Heard Miss A.N. Hussain, learned counsel for the petitioner. Also heard Mr. K.K. Parashar. Call for the case diary. Let this case be listed
6th of August.
on 6th of August.
13.
May I please your lordship to pass over the matter for time being. Learned counsel Mr. Motiur Rahman is on late at another courtroom.
Okay.
Item 14.
May it please your lordship. Lordship, the petitioner was arrested on 2024, and as on date, it has been 1 year, 5 months, 2 days he is on custody. Lordship, this is an
1 year?
1 year, 5 months, 2 days, lordship. He is on 518 days. Lordship, the scan copy may be called for.
Heard Mr. A. Ghoshal, learned counsel for the petitioner. Also heard Ms. N. Kakoti, learned counsel for this NCB. Let the scanned copy of the trial court records be called for. Let this case be listed again on 11th of August.
Obliged, Lordship.
Item 16.
This item may be passed over for the pending one.
Okay, why?
Actually, my file method is missing,
Okay, okay.
I know.
Item 17.
May I please, your Lordship? Lordship, Lordship, FIR is on page 8, Lordship. This is a charge sheeted matter actually, Lordship. Lordship,
Charge sheeted matter.
yes, Lordship. Lordship, FIR is on the basis of recovery of meat, Lordship. Charge sheet was filed, Lordship, under 13(1) of Assam Cattle Preservation Act with 325, Lordship.
Since when you are behind the bars?
I was not behind the bar,
No,
Lordship,
AB, man.
only
Oh,
notice.
it is AB.
Yes. Notice was given under 35(3).
Then why anticipatory bail?
Lordship,
You will receive.
Lordship, I
What
have
is
to
the
appear.
basis of apprehension?
Lordship, since 13(1), Lordship, cattle preservation. That's why, Lordship.
No, your apprehension is not. There
Lordship,
is no basis. The court can grant you bail.
yes, Lordship,
The
but
trial court may grant you bail.
Lordship, but no coercive action till that time.
No.
Because his co-accused also has been granted bail, Lordship, by this court only, Lordship. I have the copy with me.
No, that is
That is a different case.
before
Anticipatory bail, Lordship. In charge sheeted matter, same, Lordship, co-accused.
You satisfy me. Where is the apprehension? I don't see any
Lordship,
apprehension.
since 8 years, Lordship, 13(1).
There is no bar,
Yes, Lordship,
no
definitely.
embargo. You go to the trial court. Heard Mr. What is your name?
Mr. P.K. Das, Lord.
Mr. P.K. Das, learned counsel for the petitioner. This application under section 482 of PNSS has been filed by the petitioner Ayub Ali, who is apprehending his arrest in connection with PRC case number 106/2025 under section 325 of BNS, read with section 13 within bracket 1 of Assam Cattle Preservation Act 2021. Stop. The petitioner has, learned counsel for the petitioner has submitted that though the charge sheet has been laid in this case, however, the petitioner is apprehensive that if he appears before the trial court in pursuant to the summons issued by it, he may not be granted bail as offense under section 13 within bracket 1 of the Assam Cattle Preservation Act is involved in this case. Stop. On the other hand, learned additional public prosecutor submits that in this case there is no apprehension of the petitioner getting arrested since the trial court has issued summons to him and it is well within its powers to consider and grant bail in such cases. Stop. I have considered submissions made by learned counsel for both the sides. In this case, the trial court you have received summons.
Lordship, the case has been committed, Lordship. He has not received that summons.
The case is pending before the trial court after filing of the charge sheet, and the court before which the case is pending is and for the court before which the case is pending for trial does not have any embargo in considering the bail application as well as granting the same if it thinks fit to do so. Hence, the apprehension of the petitioner that he may be arrested or may not be granted bail by the trial court does not have any legal basis. Stop. Accordingly, this bail application is disposed of with an observation that the petitioner may appear before the trial court and may pray for regular bail before the said court, if so advised.
Like it.
Kindly pass over the matter for the continuation.
Why?
Senior counsel Mr. K. Chaudhary will appear in this case and take support number one.
Okay. After some time.
After some time. Ali.
May I tell you? Lordship, I am paying for transit and physical very badly. Lordship, I had this Lordship, FIR was lodged in Delhi, Lordship, and I have received the notice, Lordship, paying Lordship, Lordship. This notice has been received, Lordship, I was directed to appear on 4/5, Lordship, but I have received this notice subsequently, Lordship. Therefore, Lordship, I am apprehensive that if I appear, Lordship, I may be.
Where is the notice?
Notice page 11, Lordship. Page 11.
Notice from where? Notice under 35(3). You have earlier approached this court. Why you could not file appropriate application before the?
I'm thinking, Lordship, if I approach their Lordship, I may be arrested.
No, this court otherwise does not have jurisdiction.
Lordship, as per the Supreme Court judgment, Lordship.
That judgment says that you have to state in your petition that why you could not approach before court in Delhi. What prevented you?
Lordship,
That statement, whether have you made that statement?
Lordship, what happened, Lordship?
No, whether have you made that? You are referring to Indoria, Priya Indoria's case. Which case you are referring? Priya Indoria's case lays down the guidelines how a prayer for transit bail has to be made. In your application, you have to satisfy this court that for so and such reason, I could not go and pray before the court having jurisdiction over the matter.
The case is in trial, Lordship, investigation, Lordship, and petitioner is willing to approach to the investigation.
No, that is not what I am stating.
And if Lordship petitioner go, Lordship, then he may be arrested, Lordship. As per the notice, Lordship, he has not been complied the conditions of this notice, Lordship. Because he received this notice subsequently, Lordship. Kindly, Lordship, he is ever ready to appear, Lordship.
Now, where is the statement that you, for this or that reason, you could not approach the court in Delhi?
Paragraph 4, Lordship.
Paragraph
4, Lordship, the petitioner states that paragraph 4 of my petition, Lordship, I have stated, Lordship. But he was not immediately informed about the notice as he was not available for some days. The notice was handed over to the petitioner, but in the meantime, the date mentioned for appearance of Robert.
No, that would be applicable. That statement is enough if otherwise this court is having jurisdiction. In cases where is Priya? Yes, Mr. Parashar.
How we take care of the claim and now application on otherwise, only for the limited period of
No. that this court has jurisdiction to grant such orders, but he has to satisfy that for so and so reason he could not approach before the court having jurisdiction. That statement is not there. Yes, Mr. Majumdar. What guidelines are there in Priya and Gloria's case?
Paragraph 45, Lordship, of the judgment. May I refer to them?
Yes.
Paragraph 45 of the judgment of Lordship.
Yes.
At the same time, we are also mindful of the fact that the accused cannot seek full-fledged anticipatory bail in a state where he is a resident when the FIR has been registered in a different state. However, in view of what we have discussed above, he would be entitled to seek a transit anticipatory bail from the Court of Session or High Court in the state where he is reside, which necessary is to be a limited duration so as to seek regular anticipatory bail from the court of competent jurisdiction. The need for such a provision is to secure the liberty of the individual concerned.
No, that is okay. But the Supreme Court has observed in this case, Priya Induria's case, that while filing an application for transit bail, a statement has to be given as to what prevented you from approaching the jurisdictional court. What is the difficulty? Then after considering that difficulty only, the court will consider is it a fit case for. Otherwise, the notice was issued in this case in the month of April. Now it is July. You could have well approached the jurisdictional court.
I have filed this petition.
You had one paragraph. What prevented you from
Lordship, I may be allowed filing
additional affidavit in pursuant to the directions observation made in the Priya Indoria's case? You go through the judgment, comply with the judgment, we will give you relief. Heard Mr. A.M.S. Majumdar, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. Learned counsel for the petitioner has prayed for allowing the petitioner to file an additional affidavit to bring on record certain facts which are relevant for consideration of this application for anticipatory transit bail. The prayer is allowed. When let this matter be listed after a week.
Date may be fixed, then I can.
On 29th of July.
Item 20.
Return code. Yes, Mr. Gogoi.
Page 8, that's the file.
POSCO.
POSCO is here, it is not a main accused. Main accused already arrested. This is the order of the main accused.
7/2025. Let also the case diary be called for. List this matter on 31/7.
Is possible I may allow to appear before?
Not now. Let the case diary come.
Item 21.
Yes.
This is clearest well, Lordship, and the POSCO section 4 is there, Lordship. But for a moment, Lordship, kindly come to page number 16, the original FIR, Lordship. After 3 years of occurrence, Lordship, they have closed the FIR, Lordship. But before 3 years, Lordship, when she was the Lordship at
4th. Let this call for the case diary. Let this case be listed on 4th of August.
Deeply obliged.
Item 22.
Obliged.
May I please your lordship? The petitioner before your lordship is a registered owner of a vehicle lordship. FIR lordship is at page number 17. 17. Case is listed under section 11(1)(a) of the Prevention of Cruelty to Animal Act and 13(1) of Assam Cattle Preservation Act. 17 is the FIR lordship.
Yes. Who are you?
I'm registered owner lordship of the vehicle lordship. And lordship, if lordship kindly come to page number 22. That is the order passed by the learned court below in the Zimma petition lordship. Only first paragraph, that would be relevant. Page number 22, madam.
Yes.
The Zimma petitioners of petition number so-and-so are represented by their respective learned engaged counsel. As called for white order dated so-and-so, the report of the IO is received. IO has stated in the report that as per the seizure receipt issued by the Traders Association, the cattle were purchased in the name of so-and-so and seized cattle are not required for the purpose of further investigation. So, lordship, considering that, lordship, Zimma of the cattle were given, as well as lordship, the vehicle of the petitioners was also given in the custody of the petitioner. Now, lordship, as because in the FIR, lordship, the last paragraph says that, lordship, strict action may be taken, including the registered owner of the aforesaid vehicle. So, lordship, I am intending arrest, lordship. Zimma has already been given, lordship. And lordship, the cattle were purchased by one person that has been ascertained by the learned court below while allowing the Zimma petition.
Yes. Okay. Heard Mr. M. Ahmed, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 482 of BNSS 2023 has been filed by the petitioner, namely Safiqul Alam Chaudhry, who is apprehending his arrest in connection with Bipuria PS case number 136/2025. What is your submission regarding your complicity? Are you involved?
Even lordship, I have annexed one agreement, lordship, the agreement of lordship may kindly come to page number 20.
No, what is your submission?
My submission is that, lordship, I am the registered owner of the vehicle, lordship. That vehicle was given to one Hibzul Ali, lordship, on rent, monthly basis, and he is running that.
Okay. The gist of accusation in this case is that on which date FIR was lodged? On 2/7/2025, one Ujjal Bhuya, had lodged an FIR before the officer in charge of Vipuria police station regarding illegal transportation of livestock in a vehicle bearing registration number AS25EC0383 in violation of the provisions of Assam Cattle Preservation Act. Stop. Learned counsel for the petitioner submits that the petitioner is the owner of the vehicle which has been seized in this case. However, he submits that the said vehicle was given on rent to one Hifzul Ali, and the petitioner is not aware as to how his vehicle was used by said Hifzul Ali. Stop. He also submits that by order dated 10/7/2025, the Court of Learned Subdivisional Judicial Magistrate Lakhimpur, by order dated so and so, passed in GR case number 612/2025, the Court of Learned Subdivisional Judicial Magistrate Lakhimpur has already granted the Jimma of the seized vehicle to the petitioner, as well as the seized cattle to the owner who had purchased the same. He submits that under such circumstances, his custodial interrogation may not be necessary. However, he is apprehensive that he may be arrested in connection with this case. On the other hand, an additional public prosecutor has prayed for calling of the case diary. The prayer is allowed. Let this case be listed on 14th of August 2025. In the meanwhile, considering the submissions made by learned counsel for the petitioner as discussed in foregoing paragraph, the above named petitioner is directed to appear before the investigating officer of Bipuria PS case number 136/2025 and cooperate in the investigation. If he does so within the stipulated period, he shall be, in the event of his arrest in connection with the aforesaid case, he shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority. This lists this bail application accordingly.
Thank you, please.
Item 23.
May I prove, Lordship? Lordship, FIR is in case number 12, Lordship.
POSCO is there.
Yes, Lordship, later on it is added. Actually, Lordship, I had a affairs with the girl, Lordship, and she came out voluntarily on that.
Page number?
Lordship. Case number 12, Lordship.
What is the age of that girl?
70, Lordship.
Yes. Name.
Okay.
After, we'll peruse the case diary.
That's okay.
Item 57 from supplementary list.
May I please, Lordship? I have already taken the steps upon the respondent number 2. Serial was also called for minor. I have the interim prayer. My lord, your lordships kindly see the page number 26, 25, there are 5 and 6.
What happened to the notice?
Notice have already issued, my lord, as per office note.
You find out whether notice is served or not. No, office note says that service report has not been received. Telephonically, you may find out before lunch. What is your case?
Already, my lord, one AV has been disposed of by your lordship. Page number 25. None of the sections is applicable, my lord. After perusing the city, your lordship granted bails all the family members, my lord.
Who are you?
My lord, I am the accused number 1, my lord, in the FIR, my lord. I am the boy, my lord. They have the love affairs between the victim girl and my lord.
No, your case is on different footing. You are the main accused.
Yes, my lord, I am the main accused. But my lord, your lordship kindly see the paragraph number 5 of page number 25, my lord. Your lordship's order. Yes, my lord. But after perusing the CD, my lord, the victim girl found, my lord, she was consenting party. They have the love affairs, my lord.
So this case has to go to that bench as per the prevailing notification.
My lord.
Notification. Heard Mr. T. Sheikh,
My lord.
learned counsel for the petitioner. Also heard Mr. K. K. Parashar, learned additional public prosecutor. Learned counsel for the petitioner has submitted that the anticipatory bail application of some of the co-accused had been disposed of by a coordinate bench of this court within bracket Honorable Mr. Justice P. J. Soikia in bracket close in AB case number 541/2025, and therefore it is submitted at bar that this anticipatory bail should also be placed before the said court in pursuant to the prevailing notification of the registry in this regard. Stop. In view of the submissions made at bar, the registry is to verify and list this matter before the appropriate bench.
It may be fixed.
No, let the registry be.
Item 58.
Lordship. My lords, in item number 23, lordship, any other date may be fixed on 29, lordship.
You suggested it.
Any other date, you
28th,
not later, after 29, lordship.
30, 31,
Yes.
31. আগত কিমান ডেট দিলো previous I. No date. No date. Registry will finalize.
May I please, your lordship? But, this case is relates to my lord, the sale of my lord, the product my lord, by the hotel of the my lord, one Imran Hussain my lord, and I am the employee my lord. Kindly find my lord, page 22 is the rejection order my lord, of my additional liabilities my lord, page 22.
Yes.
My lord, page 22 is rejection order my lord, here my lord. Only my lord, reason for my lord reject my lord, after period of the case diary, it emerged that there are sufficient material found against the accused petitioner. Accordingly, the bail stand rejected my lord. And actually, my lord, I am the employee my lord. Kindly turn to page 10 my lord of my petition my lord, page 10. 9 my lord, FIR my lord, page 10 is the 11 portion.
What is the new ground?
My lord, it was my lord, actually my lord, this my lord petitioner is the employee my lord, and one my lord Imran Ahmed is the owner my lord, and he has already been released on bail my lord by this honorable court. And one Faridul Ali, he was also arrested my lord, he also has been released on bail my lord. After it,
Then why are you apprehending your?
because my lord, police is visiting me because visiting my house because my lord, I am the employee of that hotel my lord. So my lord, I want to cooperate with the investigation my lord, and want to appear my lord. And my lord, if I cooperate, my lord, my custodial interrogation may not be required in this case, my lord.
Okay. Yes.
My lord, it is not.
Okay. Let him appear. We'll call for the case diary.
My lord, he is not the owner, my lord. Actually, police is my lord. Why, my lord? They are making me my lord owner. I don't know. Kindly turn to page 10, my lord. And the owner of the hotel, Mr. Imran Ahmed, already he has been released on bail by this honorable court. And one Faridul also, my lord. So, my lord, I want to appear and cooperate with the investigation. My lord. I'll not temper or hamper with the investigation.
You are not the owner.
My lord, page 10 kindly of the affair, my lord, page 10.
Yes.
My lord, middle portion, my lord, hence the owner of the hotel, Mr. Imran Ahmed, who has already been apprehended, is found to be doing the illegal act in contravention of the provision of section 8 of the.
In the FIR, okay.
Yes, sir.
heard Mr. S.H. Sikdar learned counsel for the petitioner. Also, which item number is the
Well, 58.
58? S.H. Sikdar, learned counsel for the petitioner, also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner, namely Inamul Hussain, who is apprehending his arrest in connection with Baihata Charali PS case number 167/2025 under section 296/196 of BNS, read with section 13 within bracket 1 of Assam Cattle Preservation Act. The gist of accusation in this case is that during that on 1/7/2025, one Sumit Mahato of Bishwanath of Baihata Charali police station had lodged an FIR before the officer in charge of Baihata Charali police station, inter alia, alleging that during a search operation made on the basis of inputs received through reliable sources, 20 kgs of meat suspected to be of beef was recovered from which hotel?
Mughal Garden.
Mughal Garden, Shahi Darbar Hotel. Stop. Learned counsel for the petitioner has submitted that petitioner is only an employee of the said hotel, and one Imran Ahmed has been
Imran Hussain, madam.
Imran Hussain is the Imran Hussain
Yes, madam.
is the owner of the said hotel. He also submits that in the meanwhile, who have been granted bail?
Imran and Faridul Ali. Faridul Ali.
You are Inamul Hussain.
Yes, madam.
In the meanwhile, two of the co-accused have already been granted bail. Stop. By which court? By High Court?
Yes, madam.
By this court. The learned counsel for the petitioner submits that petitioner is ready to cooperate in the investigation as custodial interrogation, as his custodial interrogation may not be necessary in this case. Stop. On the other hand, learned additional public prosecutor has prayed for calling of the case diary. Stop. Call for the case diary. Release this matter on 14th of August 2025. In the meanwhile, considering the submissions made by learned counsel for the petitioner as discussed in the foregoing paragraphs, the above named petitioner is directed to appear before the investigating officer of Baihata Charali PS case number 167/2025 within a period of 7 days from the date of this order and cooperate in the investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with the aforesaid case, the above named petitioner shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority, with following conditions. List accordingly.
Item 59.
In this case, Lordship wanted to see the case study. Yesterday, this matter came up and
Case study is available.
in fact,
After some time. Yes, what is the submission?
my submission is that Lordship, so for the affair is concerned, Lordship, no implication, direct or indirect against me. This is one of the aspects. Other aspect, now what is my reason of apprehension? One of the reason of apprehension that I have detailed in my statement that yes, Lordship, admittedly, from my side, some amount has been paid to the accused, who is largely involved in organizing the appointment letters, Lordship, assurance of appointment letter in the name of verification. In that part, Lordship, admittedly, I have contributed some amount by selling out my landed property. In other words, Lordship, I am a victim of the entire circumstance. That is my, so my Lordship, I'm knowing these are the aspect only from my part.
Okay, verify.
That
Go through the case diary.
I have I have no nexus with this entire forgery or whatever the crime concern. That is.
You go through the case diary. Let him go through. We'll take it up after some time.
Item 60.
Yeah, please, Your Lordship. 482 application, Your Lordship. FIR at page 10, Your Lordship. In this case, my lord, the basic allegation is that one Surya Barua, CDPO, has made some corruption and irregularities in implementation of some government schemes. And the particular allegation against the present petitioner, my lord, at page 10, Your Lordship.
Yes.
Bottom para, down below.
Yes.
While Surya Barua was CDPO, public IC CDPO of Defense ICTCS project, also used to collect illegal gratification and commit corruption by engaging a private broker dalal, namely Habibur Sarkar. This petitioner is before Your Lordship. Son of late Kasem Sarkar of village Dharmasala Part 3, session. My lord, the present petitioner had no knowledge regarding this affair. He has come to know regarding this only after receiving a notice issued by the investigating officer under section 35(3), Your Lordship.
When is the date of appearance?
By tomorrow, Your Lordship.
Appear before the investigating
I am
officer.
ready to appear, Your Lordship, but he is apprehending arrest. Allegation is
Yes.
there.
There is
Protection may be given, my lord.
Suppose he appears, then you will not arrest him. They will not arrest you.
But some protection may be given.
No, why are you apprehending?
I look at page 9, Your Lordship. I have been made as accused number 3, Your Lordship. Accused number 1 is Surya Barua, CDPO. 2 is one of the staff of a CDPO, Your Lordship. And 3 is present petitioner, Your Lordship. My lord, sections are non-bailable, my lord. He is apprehending arrest, Your Lordship.
But accusation against you is also there.
I will cooperate, my lord. Some protection may be. Similar case, we are also dispose of the matter by directly.
Mr. What is your name?
Yeah.
A. Rahman, learned counsel for the petitioner. Also heard Mr. P. Kotoki, learned special public prosecutor, CM Vigilance Cell. This application under section 482 of BNSS has been filed by the petitioner Habibur Rahman Sarkar, alias Habibur Rahman, who is apprehending his arrest in connection with Vigilance PS case number 14/2025 under section 61 within bracket 2/318 within bracket 4/316 within bracket 2/316 within bracket 5 of BNS read with section 313 within bracket 1 within bracket small a/13 within bracket 2 and 12 of the Prevention of Corruption Act 1988. The gist of accusation is that on 17/4/2025, one Simul Sarkar and five others had lodged an FIR before the Superintendent of Police, Chief Minister Special Vigilance Cell Assam, inter alia alleging the accusation of corruption against one Shri Surjo Barua, CDPO, Debitola ICDS. Stop. Learned counsel for the petitioner has no. In the FIR, accusation has also been made against the petitioner of helping the main accused in collecting the illegal gratification. The petitioner, learned counsel for the petitioner, has submitted that the petitioner has received, where is the notice?
Yes, 14 members.
Received a notice under section 35 within bracket 3 of BNS S, whereby he has been directed to appear before the investigating officer of the aforesaid case on 23/7/2025 and to cooperate in investigation. Learned counsel for the petitioner submits that since non-bailable offences are involved in this case, he apprehends that he may be arrested in connection with he may be arrested if he appears before the investigating officer. On the other hand, learned special public prosecutor has submitted that the date of appearance mentioned in the notice under section 35 within bracket 3 BNSS has not yet lapsed and it is fixed tomorrow, that is on 23rd July. And if the petitioner appears before the investigating officer and cooperates in the investigation, there is no reason for arresting him, and therefore the apprehension of the petitioner is without any basis. I have considered the submissions made by learned counsel for both the parties. Stop. In view of the submissions made by learned special public prosecutor, CM Vigilance Cell, and also in view of the fact that the date of appearance mentioned in the notice under section 35(3) of BNSS, which was served on the petitioner, has not yet lapsed, and therefore the apprehension of getting arrested does not have any basis. The notice under section 35(3) of BNSS is issued mainly when the investigating officer does not intend to arrest a person or when the custodial interrogation may not be necessary. Stop. In view of above, this anticipatory bail is disposed of without finding any merit in it, with a direction to the petitioner to appear before the investigating officer in pursuant to the notice issued to him under section 35(3) of BNSS.
Timing item 13.
Sincere apology, my lord, I was in lack. Only NCR in this case, my lord, very old case. I was, by virtue of non-bailable warrant, my lord, I was taken into custody on 28/8/24, my lord. At this stage, only NCR, my lord. It's from.
Heard Mr. A.S. Tapada, learned counsel for the petitioner, also heard Mr. K.K. Das, learned additional public prosecutor. Call for the scanned copy of the trial court records. The registry to take steps for requisitioning this scan copy. Let this case be listed on 11th of August.
Timing item 18.
Wait, please allow. My lord, the petitioner is presently working as a drug inspector, my lord, in a temporary capacity. He was appointed under regulation 3F. Now, my lord, the government of, I'm giving this little background, this is necessary, my lord. Government of Assam sometimes in 2015 took a policy decision that all the 3F appointees who have put in between 9 years and 22 years of ad hoc service, their engagement would be regularized. My lord, in terms of the said policy, many were regularized. In fact, some were not. Then I, my lord, along with this present petitioner and another person who also is a drug inspector and others, we filed litigation, my lord. In due course of time, my lord, eventually all were regularized except the gentleman Purno Hindu Mudoy, Pankaj Kakoti. Now, my lord, if your lordship should kindly come to the additional affidavit which I have filed at page 91. Now, there is a direction by my prayer was rejected. So, my lord, there is a direction now given by the High Court. Please come to page 91, para 70.
Yes.
Under such circumstances, this court is of the considered view that matter will require fresh consideration in the hands of the government for considering the case of the petitioner for regularization in terms of OM dated 16/3/15. Government will examine the case of the petitioner as also the contentions raised before this court that several incumbents who are regularized, who are given the benefit of regularization under OM dated 16/3/15, did not fulfill the criteria. Nevertheless, the benefit of regularization was conferred. Then, my lord, will kindly come to para 19 at next page. In view of all this above, the matter stands relegated to the respondent department to reconsider and revisit the case of the petitioner for writ petitioner by considering all the attending facts, including the cases of persons regularized under Regulation 3F under various departments, including Department of Health and Family Welfare. My lord, instead of regularizing the service of the petitioner, my lord, thereafter what the government did, my lord, government issued an order whereby in my place, my lord, other incumbents were transferred, but we were without any posting. Then we again filed a writ petition. Now there is an order protecting our service. That is under Regulation 3F. Lordship knows, my lord, I am not a public servant as on date. I'm a just a 3F appointee. So if I am not a public servant, where is the question of invoking, my lord, the Prevention of Corruption Act? So that is a fundamental issue, my lord. Perhaps I'll have to file a quashing petition for this against this affair. Now coming to the present case, my lord, now a case of disproportionate asset is sought to be made out by disregarding my wife's income. That's the very simple case, my lord. I have appeared before the authority. My statements have been recorded. But, my lord, I have been advised that I apprehend, my lord, having regard to the nature of the attitude of the respondents, my lord, instead of regularizing my service, now this has been done. And in the calculation also, my lord, my wife's income has altogether been ignored, my lord. Now, if, for example, my lord, page 103 to 133 is the IT return of my wife. That is from the check period. And the check period is, my lord, 2006 to 2021. And my, yes, now come to the actual facts, my lord. At page 190, page 48, my lord. Computation of the statement of assets, income and expenditure. There is yet to be a master-servant relationship in the true sense of the term, as is understood, my lord. Total assets held at the end of the check period, 42 lakhs. Income from the known source during the check period, 66 lakhs. Expenditure incurred during check period, 43 lakhs. Excess of expenditure, 19 lakhs. And if your lordship would kindly come to the inquiry report, where they're referring to my wife's thing everywhere, my lord, please come to page 46. So perhaps, my lord, it's a very bad case as far as prosecution is concerned, my lord. Now please come to 5.5, my lord, the fifth line at page 46 on the right hand side top. Hence, there is every probable hypothesis that suspected officer had some other illegal income in addition to his known source of income. Further, while going through the account statement, it was found that an amount of rupees 7.75 lakh has been self-deposited by the suspect. My lord, in 14 years, I cannot deposit 7.75 lakhs. You're making out a case. And an amount of 7,45,000 have been deposited between 11/9/2006 and 28/3/21.
During regular inquiry, you cooperated in.
Yes, my lord. Yes, I did. Even now also, my lord, after the registration of the affair also I appeared.
Then where is the apprehension?
No, my apprehension is, my lord, now regularly they are calling me.
You go and cooperate.
No, I'll cooperate, my lord. Lordship will protect. I'll definitely cooperate.
Yes, Mr. Kotoki.
Yes.
Yes. Question of flight tricks.
No, my lord, I am a 3F appointee. Where do I go, my lord? Even I appeared on last Saturday.
No, whether custodial interrogation is required or not. If he otherwise appears before.
On last Saturday also I appeared.
So they say that both the gravity and the norm evolve. So they say that custodial may be required.
May be required. So he has genuine apprehension that
And my lord, if my wife's income is taken note of, there is none, my lord, and they have taken note of my wife's deposit.
No, we are not going into merits. Now, if they are apprehending that you may flee.
I'll not leave the station, my lord.
Station means in Guwahati or Assam?
Assam. I'll not leave Assam, my lord. Lordship may impose that condition.
Heard Mr. K. N. Chaudhary, learned senior counsel assisted by Mr. M. Ahmed, learned counsel for the petitioner. Also heard Mr. P. Kotoki, learned Special Public Prosecutor, CM Vigilance said, this application under Section 482 of BNSS 2023 has been filed by the petitioner, namely Purno Sindhu Mudoi, who is apprehending his arrest in connection with Vigilance Police Station case number 18/2025 under section 13 within bracket 1 within bracket small b /13 within bracket 2 of the Prevention of Corruption Act 1988. Learned, the gist of accusation in this case is that on 26/6/2025, one Thagish Dole, Inspector of Police, had lodged an FIR before the officer in charge of Vigilance Police Station, inter alia, alleging that on the basis of a regular inquiry within bracket RE number 10/2025, the regular inquiry which was conducted against the present petitioner, he has been found to have to possess assets disproportionate to his known source of income. Stop. Learned senior counsel for the petitioner has submitted that the petitioner has been appointed temporarily as drug inspector under regulation 3F, and therefore he is still now not a regular government servant, and he submits that the provisions of Prevention of Corruption Act 1988 is not applicable in the case of petitioner. He further submits that during the regular inquiry, while coming to a conclusion that the petitioner possesses assets disproportionate to his known source of income, the income of the wife of the petitioner has been ignored by the inquiry officer. He further submits that the petitioner had cooperated during regular inquiry, and even after filing of the FIR against him, he has appeared before the investigating officer and has cooperated in the investigation. However, he is apprehending that he may be arrested in connection with the aforesaid case. On the other hand, learned Special Public Prosecutor has submitted that the investigating officer of this case has filed the SP of CM Vigilance Cell has filed a written bail objection, has communicated a letter dated 21/7/2025 to him, wherein the investigating authority is objecting to grant of anticipatory bail to the petitioner at this stage on the ground that the offense involved in offense alleged in this case involves huge quantity of money. Further, it is also submitted by learned Special Public Prosecutor that there is a possibility of flight risks, and therefore anticipatory bail may not be granted to the petitioner at this stage. I have heard submissions made by learned counsel for both the sides, both sides. Though accusation against the petitioner is his having assets disproportionate to his known source of income is there in this case. However, it appears that he has been cooperating in the investigation, in the regular inquiry as well as in the investigation. And there is no basis of speculating that he may not cooperate in the investigation and he may flee away from the course of justice. Even if any such apprehension is there, same may be addressed by imposing appropriate condition while granting anticipatory bail to this case, to the petitioner. Since the petitioner has been appearing regularly and is also ready to appear, to continue to appear before the investigating officer and cooperate in the investigation, his custodial interrogation may not be necessary if he cooperates in the investigation. In view of above, it is directed that if the petitioner is arrested in connection with CM Vigilance Cell, CMPS case, in connection with Vigilance PS case number 18/2025, he shall be allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions, number 1 and number 2. How to ensure that you will not
Without seeking permission from the arresting authority will not be in the
number
state
1
of
and
Assam.
number 2. Number 3 also, the petitioner during the course of the investigation shall not leave the state of Assam without taking prior approval of the investigating officer of Vigilance PS case number 18/2025. This anticipatory bail application is accordingly disposed of.
Item 24.
What is the matter? I have not. Force code. Okay. Under the provision of the BSF Act.
Has been taken district jail of Hubli. In any case, Lordship, this is not the case which would be registered as a
Wrong registration.
confirmation.
What is your prayer?
Lordship, actually, the time when this particular file, yes, maybe the category of the case was categorized under the wrong head because it comes under civil rule, court-martial proceedings. But at that point of time, when this case was filed, at that point of time, what was happening was that this particular petitioner, he was under lockup. And at the same time, though the General Security Force Court had sentenced a particular award against him, that was not given the finality. And he was waiting for the finality from 31/1/25 till the point this particular case was filed. So though it was a little bit premature in the nature, since he was waiting, our prayer was that he should be, if at all he's been convicted under any particular case which is under section 46 of the BSF Act, that is under civil offense. So he should be, if at all he is convicted, then he should be sent to judicial custody, like as per the law. But he was under lockup at that point of time, and since it was a bit like illegal, since his family members was also not able to meet him, and he was also not given any copy of this sentence also. So our basically at that point of time, this case was made out of the fact that since he was under illegal lockup, and also we were praying for expeditious confirmation of that particular award. And if at all, if he has also appealed under section 117 of 2 of the BSF Act,
Appeal lies before whom?
against the this one, the competent authority, that is the Director General.
Okay.
So now what has happened is that at that point they assumed that the sentence was awarded, and so they had also appealed. But that appeal is also premature now. The fact is that since the award was not given finality by the competent authority at that point of time, but when this case was filed and notice was issued, in the meantime, it has come to the knowledge of the family of the petitioner. Yes, he has been sent to prison. So now, since like our prayer has been already, like it has been taken care of, and also the fact that now he has been sent, we will be challenging the order of the particular appeal if it is disposed of and by the competent authority. So in the meantime, this matter does not pertain, like it does not, like the main part
It has become infructuous.
infrastructure at this point of time. So the Lordship may dispose of this matter accordingly.
Heard Mr. W.R. Medhi, learned counsel for the petitioner. Also heard Mr. R.K. Dev Chaudhary, learned deputy SGI. Learned counsel for the petitioner has, yes.
Yes,
No, but it is now being dismissed on becoming infructuous. I am not stating many facts. It is unnecessary. Learned counsel for the petitioner has submitted that the petitioner had approached this court against the order dated 31/1/2025 delivered in the open court by which authority has?
The GSFC, Security Force Code.
By the General Security Force Court, and whereby the petitioner was convicted under section 12 of the POSCO, imprisonment for 5 years along with dismissal from service. Dismissed on becoming infructuous.
Item 25.
Made, please, your lordship. Lordship, this is a regular bail application, lordship. In this case, this petitioner in jail custody for 190 days, lordship. Here, FIR, lordship, will find on page 16, lordship. May I read the FIR, lordship?
Yes.
It is respectfully submitted that on 31/5/2024 night about 11 p.m. my daughter's such and such aged about
Live streaming to off korbo POSCO case. Is it a POSCO case?
Yeah.
Yes. Yes, continue.
May I dispose of this petition, lordship?
Okay, dispose of.
I will.
Stand up.
Keep going.
Item number
CD is not available.
What is the offense?
Offense for NDPS, commercial quantity.
CD would be required.
CD was available on the last occasion. It was not returned also. Only one case was checked for FSL report, although FSL is not required in this case as per my observation.
But CD would be required.
Updated.
The last
Heard Mr. S. R. Ali, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor, who prays for some more time for producing an updated case diary. The prayer is allowed. Let this case be listed again on when?
On 28.
On 28/7 for case diary.
May please, Your Lordship. This is the 483 bail application, my lord, which is raised under section 376(3) and read with section 6 of the POSCO Act. FR is page number 8.
What is the status of trial?
They have already examined 4 PWs. Victim, mothers of the victim, and 2 others.
Since when you are behind the bars?
5/5/2024. Today, till today, 442 days I'm behind the bars. There is a lab relation between the victim. 442 days.
Victim has been examined. Victim girl, okay.
One more submission, member, technically matter. Now, victim is not
the opposite party. We have already taken steps, my lord. They have not appeared, my lord. And neither, my lord, any amicus curiae has been appointed by this.
We'll appoint one amicus curiae.
Yes, my lord. The earlier round, my lord, this is the second round of litigation, my lord. Mr. S. Das was there, my lord.
You were there in earlier case, so you know about the facts. Heard Mr. N.J. Datta, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. Though it appears that notice has been served.
Yes, my lord.
Notice on respondent number 2 has been served. However, no one has appeared for the respondent number 2. Stop. This court is inclined to appoint one amicus curiae to defend the cause of respondent number 2 in this case. Accordingly, Mr. Surajit Das is hereby appointed as amicus curiae to defend the cause of respondent number 2 in this case. The petitioner is directed to furnish the copy of bail application along with annexures to the newly appointed amicus curiae
The course of the day.
during the course of the day. The registry is also directed to reflect the name of the Mr. S. Das as amicus curiae for respondent number 2 against this case in the cause list henceforth. List this matter when?
Can it be, my lord, next Tuesday, my lord, 29 or 30, my lord?
30. Let this matter be listed on 30.
I'm
Item 30.
Lord, can this matter be at after Mel?
2.
So second half Mel, because Mr. Jet Kamar will obligation.
Item 31.
May I please, Your Lordship? My senior, Mr. S.C.K.L. is on next, so kindly pass over the matter for the time being.
For the time being,
Yes, Your Lordship.
let him come.
Be obliged.
Item 22.
May I please, Lordship? This matter
It is not available.
May. Lordship, this matter pertaining to slaughtering of cow.
Slaughtering.
Slaughtering, Lordship. I am in custody for 43 days.
What is your case?
It's case number 15, Lordship.
Whether case diary would be necessary?
No, Lordship, because I am in for 43 days and sections are punishment up to 5 years, 3 to 5 years. And during the Eid, someone has slaughtered cow and they have given us meat. We cooked it. And if you go through the allegation, Lordship, in the forwarding report, Lordship.
What is the accusation against you? You cooked the beef.
I am the petition number 1. The accusation is I am slaughtered. Petition number 2, I have boiled beef. Petition number 4 and 3, slaughtering. Petition number 5, cooked beef. And 6 have kept raw beef. And 7 to 10 have slaughtered.
All are beyond the bars for 43 days.
43 days, Lordship.
Yes, length of detention, 43 days is sufficient period. Heard, Mr. A.K. Sharma. Why case diary is not there? No intimation. Heard, Mr. A.K. Sharma. A.K. Sharma, learned counsel for the petitioners. Also heard Mr. K.K. Das, learned additional public prosecutor. This application under section 483 of BNSS has been made by the petitioners, namely 1, 2, 3, 4, 5, 6, 7, and 9, 10, who are detained behind the bars since which date? Since 9/6/2025. Within bracket for last 43 days in connection with Hojai PS case number 183/2025 under section 325/196/299 of BNS, read with section 13 and section 5 of the Assam Cattle Preservation Act 2021. The gist of accusation in this case is that on 8/6/2026, one
Sahabuddin, BDP member.
Sahabuddin had lost. Sahabuddin or Prosenjit Das, who lost the affair? Prosenjit Das. One Prosenjit Das had lodged an affair before the officer in charge of Hojai police station, inter alia, alleging that the accused persons named in the affair, including the present petitioners, have case diary would be necessary. It is beyond that. You slaughtered and threw the meat in front of temple so as to incite religious. That is a much graver offense.
This is the allegation, Lordship. This is the allegation.
Case diary would be necessary.
Lordship, we are, first of all, we are not the FIR name accused. FIR name accused has already been granted bail, Lordship.
Where?
Prime accused.
Where is the bail order?
There is a bail order, Lordship. One anticipatory bail and other regular bail, Lordship.
But the accusation is not so simple.
Not so simple, Lordship, but we are not involved. During the Eid, some has given us meat, Lordship. This is the allegation. The prime accused, that is FIR name accused, has already been granted bail. And others are granted anticipatory bail also.
No, case diary would be required.
So I may be allowed to do it.
Yes. Heard. The learned counsel for the petitioner prays for allowing the petitioner to withdraw the instant bail application. The prayer is allowed. This bail application is dismissed on withdrawal.
Item 33. In this case, I should submit it.
We'll approach the tamper.
Heard Mr. S. Nawaz, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor, who submits that though the case diary was called for, however, charge sheet has been laid in this case, bearing charge sheet number
111/25, dated 06/06/2025.
Stop. In view of the fact that the charge sheet has been laid in this case, and this bail application is disposed of with an observation that the petitioner may approach the said court if so advised.
Item 34, item 10 and 11.
One by one.
I'm appearing in item 10, my lord. And learned friend is appearing in 34, you are appearing in 11.
Which one we should take?
So we take a
Listed এটা আছিলে আহিছে নেকি ভিডিও
Potassium is gone for withdrawal.
we will be continuing after this.
Simple withdrawal.
Okay, heard Mr. M.U. Mahmood, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant bail application. The prayer is allowed. This bail application is dismissed on withdrawal.
Obliged.
Yes.
Well, my contention is that the main SI named accused persons and I are similarly situated, my lord. Same set of allegations against us, that we are involved in recruitment for Alpha. We are also engaged in providing some sort of financial support, some logistical support, my lord. But they have been granted bail on 18/6, my lord.
Next item is number no, number 11.
My lord. He purchased a plot of.
You are teacher of school or tuition? Yes, Mr. Sheikh.
Narcotic case, my lord. My first submission before your lordship, I am in detention for 2 years, 4 months, 2 days as on today. my lord. And the second submission before your lordship, coordinate bench this Guwahati High Court, my lord. Granted bail to 3 accused persons who were arrested along with me. My lord, my humble submission, my lord, on that count, my lord. If your lordship
What is the date of your arrest?
Date of arrest was 18/3, my lord, 2023. I have calculated, my lord, subject to correction.
How many witnesses are there?
13 witnesses, my lord.
How many have been examined?
Three witnesses examined. And that is reflected in the order,
Where is the bail order of the co-accused?
my lord. Lordship turn to page 22, my lord. Here, my lord, a detailed discussion has been done. Lord, your lordship will turn to page 23, para 6, my lord. May I read, my lord? That out of 13 witnesses, only 3
No,
witnesses.
okay. What is your submission?
Lordship, here, Lordship, regarding Perity, Lordship, contraband was not recovered from them, Lordship. Here, Lordship, contraband recovered from the petitioner. He was caught red-handed, Lordship.
How much is the contraband?
119.62 kgs of ganja, Lordship. He was caught red-handed, Lordship. And Lordship, yes, Lordship.
Who is he? He's the driver of the vehicle.
Yes, sir.
But regarding long incarceration,
Lordship, here charges came on 19/12/23. 19/12/23, after that, Lordship, 10 or 11 days were fixed for evidence, Lordship. And Lordship, on 2 or 3 occasions, Lordship, when witness came, Lordship, opposite party took time, Lordship. I have flagged my Lordship.
where have you flag mark?
No.
Okay, anything else?
Regarding priority lordship, I am placing on judgment lordship. I'm placing two judgment lordship. Lordship may consider.
Which para?
Para number 11 and Kasim on para number 37.
Okay, heard Mr. M.A. Sheikh, learned counsel for the petitioner. Also heard Miss M. Deka, learned counsel for the NCB. This application under section 483 of BNSS has been filed by the petitioner, namely Shah Jan Mia, who has been detained behind the bars since 18/3/2023, within bracket 18/3/2023 or 23 within bracket, for last more than 2 years, 4 months in connection with NDPS case number 133/2023 under section 20 within bracket small b small Roman 2 capital C of the N/N 29 of the NDPS Act 1985, pending before the Court of London, Additional Session Judge number 2. The gist of accusation in this case is that the NCB has lodged a complaint before the Court of Learned Session Judge, Kamrup Metro, inter alia alleging that on receipt of a reliable information through on receipt of an information through reliable sources, on 17/3/2023, that the petitioner be carrying huge quantity of ganja concealed in specially made cavities over passenger sitting area of a vehicle bearing registration number TR01B4290, a search operation was conducted, and during the Naka checking, the aforesaid vehicle was intercepted. Stop. At the time of search operation, 19 packets of ganja weighing about 119.62 kgs were recovered from the said vehicle, and the petitioner was apprehended therefrom. Learned counsel for the petitioner has submitted that the petitioner has been languishing behind the bars for more than 2 years, 4 months, and till date, out of 13 prosecution witnesses listed in the charge sheet, only 3 have been examined, and there is unlikelihood of an early culmination of the trial. Stop. Learned counsel for the petitioner has submitted that the long incarceration of the petitioner has infringed his fundamental rights guaranteed to him under Article 21 of the Constitution of India. And as such, the embargo of Section 37 of the NDPS Act has been overridden in this case, and he is entitled to get bail on that count. Stop. Learned counsel for the petitioner has also submitted that in the meanwhile, 3 of the co-accused who were also arrested along with the petitioner on the same date in the same case have already been granted bail by a coordinate bench of this court in coordinate bench of this court
It's 21.
on 8/5/2025 in bail application number 1206/2025. Stop. He therefore submits that as the petitioner stands in the same footing to that of the co-accused who have already been granted bail, he is also entitled to get bail on the principle of parity. Stop. On the ground of parity. Stop. On the other hand, learned counsel for NCB has vehemently opposed the grant of bail to the present petitioner. She submits that the present petitioner does not stand on the same footing as that of the accused persons who are already granted bail, as the seized contraband was recovered from conscious possession of the present petitioner. She also submits that in the instant case, quantity of contraband seized is of commercial quantity, and therefore the embargo of Section 37 of the NDPS Act is applicable to this case. Stop. She further submits that the delay in progress of the trial has been also caused by frequent adjournments taken by the defense counsel during the trial. She points out on 3 occasions the trial had to be adjourned on the prayer of the defense counsel. She therefore opposes the grant of bail to the present petitioner. In support of her submission, she has cited a ruling of the Apex Court in the case of Pallula Bid Ahmed Arimutta and another versus Union of India, reported in 2022 2 Supreme 409. She has also cited a ruling of the Apex Court in the case of Narcotic Control Bureau versus Kasif, reported in 2024 SEC Online SC 3848. I have considered the submissions made by learned counsel for both sides and have gone through the scanned copy of the records of NDPS case number 133/2023, which was requisitioned in connection with this case. Now you have to quote. Quote para 1011 from bail application number 329/2025. Talab Hussein, itu sahil hobo. 1011. 13, 14. 14th period of detention is 2 years, 4 months. Though the ground of parity may not be applicable in all the circumstances, as has been rightly submitted by learned counsel for the NCB, however, in this case, this court is of considered opinion that there has been a considered opinion that the detention of the petitioner is long enough and in the consider and such a long incarceration would result into infringement of fundamental rights of the petitioner guaranteed under Article 21 of the Constitution of India. Code para 16. (119 kg ganja). Code para 17. 17 from the set. 2 lakhs with 2 sureties of like amount with certain conditions. Yes. What is the acquisition?
The acquisition, it is an omnibus statement.
Where is the affair?
Affair is a page 10 Lordship. It is a communication to the Additional Director General of Police regarding reference email dated so and so. Page number 10 Lordship. Under this reference Lordship, the gist of acquisition is fake appointment letter has been issued under the seal and signature of the.
No, where is the affair?
That has been, this is the first communication.
This is treated as an affair, no?
Yes, sir. This is
Okay,
treated as-
okay, okay.
So the gist of acquisition, that is only that the fake appointment letter has been issued under the signature of Director of Water Resource.
You are not named.
No, I'm not named.
Why are you apprehending your relatives?
I have already cited by filing my additional affidavit wherein I have annexed this
35(3) notice.
35(3) notice.
What is the date?
The date was long back. It was 2nd of July.
Why have you lapsed?
Some unavoidable circumstances.
Yes, Mr. Parash.
Otherwise, there are some, one has made this fake appointment letter, and some has circulated it. And some person collected money from the candidates. for getting the job. Malad. Now regarding this, this candidate, Malad, petitioner, Malad, she said that she has given money. So if she has given money,
That
so
is
where is
also-
the apprehension, Malad? Otherwise, Malad, yes, that is also an offense.
That is also an
That
offense.
is also an offense. But now only, Malad,
She has lapsed. She has defaulted in appearing on the date. Okay, okay. Heard Ms. T. Soom, learned counsel for the petitioner. Also heard Mr. K.K. Parashar.
this case yesterday came from motion and today, Malad, I have. But regarding
Let her-
collecting money, Malad,
There is no accusation against her.
till now, Malad, I have not found regarding collected money by this petitioner.
Let her appear.
Let her.
We are disposing of this. The क्या लिखा? K.K. Parashar. This application under section 482 of BNSS has been filed by the petitioner, namely Karishma Bhuya, who is apprehending her arrest in connection with CIDPS case number 4/2025 under section 61 within bracket 2/318 within bracket 4/336 within bracket 3/340 within bracket 2 of BNS. The gist of accusation in this case is that on 10/2/2025, one FIR has been lodged by one Bhaskar Jyoti Sharma, inter alia, alleging that certain miscreants are circulating fake letters with a forged signature of the first informant to various divisions under water resource development. Where is the accusation of taking money? That is not there.
That is not there in the.
It was found in the investigation. Okay. Okay.
Lakhs of rupees.
Learned counsel for the petitioner has submitted that the petitioner is not named in the FIR. However, she has received notice under section 35(3) of BNSS in connection with the aforesaid case, and wherein she was directed to appear before the investigating officer on 2/7/2025. Stop. Learned counsel for the petitioner further submits that due to some personal difficulty, she defaulted in appearing before the investigating officer on the date mentioned in the said notice, hence, now she is apprehensive that if she appears now before the investigating officer, she may be arrested in connection with this case. Learned counsel on the other hand, learned additional public prosecutor has produced the case diary of CIDPS case number what is the number? CIDPS case number 4/2025 and has submitted that the accusation against the petitioner is that she offered money for getting appointment in the water resource department, and in this case several persons are involved in circulating fake appointment letters and collecting money from the prospective candidates. Mr. Parashar, you are opposing. Learned counsel for the petitioner, learned additional public prosecutor, therefore opposes the grant of anticipatory bail to the petitioner at this stage. I have considered the submissions made by learned counsel for both the sides and have perused the case diary of CIDPS case number 4/2025. The main allegation in this case is of forging the signature of the first informant, that is the chief engineer of Water Resource Department, and circulating fake letter in his name. Regarding the said accusation, there is no incriminating materials against the petitioner in this case. The suspicion against her is of offering money to get a post in the aforesaid department through back door. Stop. It also appears that the investigating officer also issued notice under section 335 within bracket 3 of BNSS, which indicates primarily that the custodial interrogation of the petitioner may not be necessary. However, as she has defaulted in appearing before the investigating officer on the said date, her apprehension of getting arrested appears to be genuine. Stop. This court is of considered opinion that if she cooperate in the investigation, her custodial detention may not be necessary for fair completion of the investigation. Stop. In view of above, this anticipatory bail application is disposed of with a direction to the above named petitioner to appear before the investigating officer of the CIDPS case number 4/2025 within a period of 10 days from the date of this order and cooperate in the investigation. Stop. If she does so within the stipulated period of time, in the event of her arrest in connection with the aforesaid case, she shall be allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions, number 1 and 2. Send back the case diary. This
Item 35.
This anticipatory bail is accordingly disposed of. Item number?
Maybe the Lordship.
Is there
Is that, my lord, in this case, actually, what happened, he was in custody for last 4.5 years, 6 years, my lord, in a homeless place, my lord. On the date of release, he was arrested, my lord, in a case which was registered in 2024, man.
in connection with?
The Tongla PS case number, my lord. So, 59 of 2024, my lord. It was registered on 5/10/18
No, he was in jail for 4 years,
for 6 years, my lord.
6 years.
More than around 6 years.
In connection with which case?
Near case number 9 of 2020, 2 of 2019, my lord.
Near.
And when I was bail order was on 9/6/2025, my lord, and lecture 3. And on 10, I submitted my bail bond, my lord. And on the date of release,
On which date you were released?
on 10/6, my lord.
10/6.
10/6 itself, I was taken into custody, my lord, and I was produced before the court of
In connection with Tongla?
Tongla PS case, my lord.
When the Tongla was filed?
It
Tongla
was
case.
registered on year 2024, my lord. September. That FIR your lordship will find at lecture 1, my lord.
Now what they have violated?
They violated, my lord, as per episcopal decision, my lord, if I'm in custody, the requirement of the state authority to inform apprise the court before taking the person in custody, my lord, about the any other offences where I am unpaid, my lord. For last 6 years, in 2024, I was in custody. So Central Jail Guwahati, they know it very well. And it was a duty, and they said I made a conspiracy from the jail. I had a talk with the main accused, my lord. If that is the case, my lord, then is it not duty of the authority to inform the jail authority that these are the case pending, my lord? There is Sheikh Abdullah's case, my lord. I am relying paragraph 5, my lord.
No, but there is violation of.
Yes, my lord, but apparently violation. 2024, they have registered the case. And they saying that from 2024, I had a discussion with the main accused, my lord. Main accused went to jail authority, district jail, they had a talk with me that they want to say in the forwarding report, my lord. If that is that, my lord, that is prior to my release, my lord. All things took place, my lord. If your lordship sees the forwarding report, my lord.
No, what is the requirement?
Requirement is that, yes, says that we are amazed that the statement we should expect that if the order of bail is filed as us, state is considered fit to arrest any petitioner for any other offences. This Bowden need to apprise the court before taking this person into custody, especially.
Which court?
But the court, the Nia court, man. That these are the cases pending against me.
Which granted the bail.
Bail, yes. That these are the cases pending because against
no,
me.
whether in this case that was
No,
informed.
that was not done, man. Because otherwise you would have filed for anticipated bail, man. That is where your lordship can have a look, my lord. That is in.
No, that judgment is with me.
And that is relied by Justice Bhuya, my lord, in case of in our High Court decision, my lord. That is.
But how will we verify that whether that was informed to Nia court or not?
Because forwarding report itself clearly says, my lord.
Where is the forwarding report?
Forwarding report, your lordship can kindly see. That is page 48, my lord. It starts from 47, my lord.
Section 18 of the unlawful activity.
18 is conspiracy.
Which chapter?
Chapter.
It is covered by 43D.
Is
Putul, unlawful activity.
Chapter 4, my lord.
Is it covered under 43?
43, less than 5 years, my lord.
Okay. Where is the forwarding report?
Forwarding report is page 46, my lord. Well, I come page 47, my lord. The relevant portion your lordship will find.
Just a minute.
Is 48, my lord. During investigation, the grounds of arrest, my lord.
Chapter 4 is there.
Chapter 4 is there, I understand, my lord.
In case of 4, the embargo of 43D is applicable.
Yeah, I understand, my lord.
How will you overcome that?
Now, prima facie also no cases, my lord. If your lordship sees, I am in custody, a person, I mean that doing a NIA case, but I cannot mean any person, my lord. I have to take permission from the court.
No,
the jail authority will not allow him.
For that perusal of the case diary.
I understand, my lord. Your lordship.
Because of this embargo, 43D.
43D, my lord.
You have to overcome this also.
43, yes, I understand, my lordship is correct, my lord. 43D says, my lord.
43D5.
5, my lord, yes. 43, notwithstanding, public prosecutor has given opportunity, such person shall not be released on bail on perusal of the case that a report made under section 173 is opinion there are reasonable grounds for believing accusation against person primarily through.
Perusal of the case diary would be necessary.
Yes, in that case, 43D. Otherwise, also, my lord, another constitutional provision that has violated Article 21 because they have withheld the information, my lord.
So it will override the 43D.
Yes, override my 43D. Because
let the case diary come. Yeah. We'll have a long hearing.
because that has been relied by our High Court also in.
Okay. Heard Mr. P. Kotoki, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor, who prays for some more time for producing the case diary. When you can produce? No, let him take time. If you default, it may go in favor of the petitioner. So choose your date.
Okay, 31st.
The prayer is allowed. Let this case be listed on 31st, 31/7.
From supplementary list. Okay.
Yes.
Lordship, some amount of cannabis, Lordship, ganja were recovered.
How much?
511 kg, Lordship. From
It is huge amount.
Huge amount, but Lordship, the case stories, Lordship, different, Lordship. Those contrabands were recovered from a Lordship, hay house. It's not recovered from a dwelling house. Lordship, when these contrabands were recovered, Lordship, the petitioner was not at home, Lordship. He and his wife were in the paternal house of wife, Lordship. And thereafter, Lordship, based on information, Lordship, the custom department visited the premises, and Lordship, from their Lordship, they have claimed that they have recovered this amount of cannabis from the premises, Lordship. One abandoned house is there, Lordship, which is nearby their main house, Lordship. So this is the story, Lordship. But we are here before your Lordship that Section 47 of BNSS was not complied, Lordship. Vihan Kumar and Praveen Purkas.
When you were arrested?
Lordship, we were arrested on 5/9/24. Almost 11 months I'm behind the bar, Lordship. And trial is also started, Lordship.
Where is the notice?
Lordship, in the TCR, Lordship.
You have not flagged it.
Lordship, page number 56. I have not flagged, but I'll check it. Page number 56, Lord. They have just simply, they have mentioned, Lordship, for the offense only. No detailed grounds of arrest are mentioned, Lordship, in view of para 18 of Vihan Kumar, Lordship. And in Pankaj Bansal versus Union of India also, Lordship, that grounds of arrest must be communicated in writing to the accused at the time of arrest. And that mere mechanical reproduction of grounds without application of mind.
When the judgment of Pankaj Bansal was delivered?
It is, Pankaj Bansal is discussed in Vihan Kumar, Lordship.
No, when it was delivered? No, but in 47 notice, read 47 notice. It clearly states about the acquisition.
Detailed information, detailed grounds of arrest is not there, Lordship, which is discussed in Vihan Kumar para 18, Lordship. That is my submission, Lordship.
What detail?
Detail means, Lordship, in that notice, Lordship, just that offense, under that offense is booked, that much is written there, Lordship. In case the Lordship,
no, it clearly states that you were found in possession of such and such contraband.
But
What
Lordship,
more is required?
But Lordship, that was not conscious possession and Lordship physical possession, because I was not there. I surrendered, Lordship, after 3 days.
No, that is a different issue.
Yes.
47 is a different issue. In 47, it appears that basic facts were told to you. So 47 goes.
Now, Lordship, I'm relying, may please, for your Lordship, see,
Your main plea is that 47 and that you were not there in.
Yes, Lordship. That, and apart from these 47, Lordship, I have one another, Lordship,
part of submission, Lordship, and that is based on, Lordship, definition of Hang and Ganja, Lordship, which is described in section, Lordship. I have placed some orders of different high courts, Lordship.
Okay, what was the FSL report say?
FSL, definitely FSL will, Lordship, give positive, but that is not the ultimate thing, Lordship, because in entire record, it's a voluminous record, Lordship. In entire record, nowhere it is mentioned that fruiting or flowering tops are there, Lordship.
No,
so it is
but
only greeny leaves, Lordship. In case of greeny leaves, Lordship, that greeny leaves does not comes under the definition.
where it is? Show
Lordship.
me.
Lordship, first, Lordship, if I come to the, Lordship, section, Lordship.
No, where seizure list? Show me the seizure.
Lordship, even in the TCR also, it is available. Otherwise,
You are ready? You are ready?
Chip, I have a prayer to make.
Even on last occasion.
Today I thought you will be ready.
Your Lordship, we need 1 week time to file our objection.
That prayer has to be made initially.
Earlier made, Lordship.
Actually, Your Lordship, the IO has transferred. That's why we were not able to obtain the objection.
Okay, let them file objection.
IO is appearing in the trial court, Lordship. They also made the same similar submission in the last occasion.
You flag the documents on which you are relying, the seizure list, and your second submission.
Seizure is in the petition, Lordship, page number 10, Lordship. Just for a moment, Lordship will come to page number 10, Exhibit 2.
Yes.
Lordship will see in the middle portion, Lordship, dry green plant-like material suspected to be ganja.
Where?
Lordship, in the middle part, Lordship will the column number 2. Page number 10, column number 2.
Plant-like material. It may include fruiting tops.
No, Lordship. In other pages, Lordship, they have mentioned that green leafy material.
Show me that page.
Lordship. Green leafy materials.
You come prepared. Let them also file their objection.
Otherwise, Lordship, it is available in the record, Lordship. So,
because you are on the merit. Your 47 plea is not very strong. You can argue on that also. Heard Mr. M. And if you make such request for adjournment, you have to interrupt before he starts, so that time is not wasted. Heard Mr. M. Rahman, learned counsel for the petitioner. Also heard Mr. What is your name? R. Hussain, learned counsel for NCB, who prays for allowing the NCB to file, prays for some more time for allowing the NCB to file written objection against the prayer for bail of the petitioner. The prayer is allowed. When will you file?
25.
Your Lordship, any date next week.
Let this case be listed again on 29th of July.
Give your bench.
Will you bench?
63 and 64.
Lordship, may kindly take up the first BA 2077.
Which? 64.
But here he was arrested on 31st May 2025. So as on today, 53 days behind the bar. And section 316, subsection 5 and section 3 5 BNS and 66.
What is 316?
316, it is applicable only to the government servant. He is not a bank employee, neither a government servant nor bank employee.
Breach of trust.
So 316.5, it suggests criminal breach of trust, my lord, by a public servant. Lordship. So petitioner, my lord, neither government servant nor my lord, bank employee. So custodial, my lord, if your lordship see the FIR, my lord.
What is the punishment in 316?
Punishment, my lord, 316, otherwise, my lord, it is 7 years. But if 3165, my lord, consider, then it will be, my lord, up to life, my lord. 3165, my lord, may not be applicable.
Who are you?
My lord, I am, my lord, working as a, my lord, service executive, my lord, in HDFC Life. I am no way, my lord, associated with the Bandhan Bank. So, lordship, kindly come to the FIR first, my lord. I am associated with HDFC Life. Allegation is that I have introduced, my lord, the petition informant with the, my lord, bank manager. And bank manager, my lord, now he is on interim, my lord. FIR, lordship, vernacular is at page 18, my lord.
Yes.
My lord, kindly see Asami, my lord, there is a 3 accused person, Kongton Das, that is me, my lord. Next, my lord, branch manager, Bandhan Bank, and number 3, Minmoy Polita. And branch manager is on interim, my lord. His case is also listed today, my lord, perhaps item number 42, 41. So, my lord, may I read the FIR, my lord?
Yes.
সম্মানপূর্বক বিনীত নিবেদন এই যে বাক্সা জিলাৰ মুছলপুৰ থানাৰ অন্তৰ্গত আঠিয়াবাৰী চকত মোৰ এখন স্থায়ী গেলামালৰ দোকান আছে। যোৱা 20/11/24 তাৰিখে 1 নম্বৰ আসামীয়ে মোৰ দোকানলৈ অহাত মই তেওঁৰ লগত চিনাকি হওঁ আৰু 1 নম্বৰ আসামীয়ে মোক তেওঁৰ বেংকৰ কৰ্মচাৰী বুলি চিনাকি দিয়ে। তাৰ পিছতে উক্ত 1 নম্বৰ আসামীয়ে মোৰ দোকানলৈ আহি মোৰ নামত এটি কারেন্ট একাউন্ট খুলি দি মোক এটি ব্যৱসায় লোন দিব বুলি কৈ 3 নম্বৰ আসামী অৰ্থাৎ বন্ধন বেংকৰ কৰ্মচাৰী এজনক মাতি আনি মোৰ পৰা পান কাৰ্ড, ভোটাৰ কাৰ্ড, আধাৰ কাৰ্ড, ট্ৰেড লাইসেন্স, RTR ফাইল আৰু পাছপোৰ্ট ফটো আদি লগতে বিভিন্ন ফৰ্ম, খালী কাগজ আদি চহী লয়। That is accused number 3, মানে ব্যৱসায় লোন দিয়াৰ আশ্বাসেৰে এটি কারেন্ট একাউন্ট নাম্বাৰ সো বন্ধন বেংকৰ নলবাৰী শাখাত খুলি দিয়ে। কিন্তু দুখৰ বিষয় তেওঁলোকে মোক ব্যৱসায় লোনটো কৰি দিব নোৱাৰো বুলি ক'লে আৰু তাৰ পিছত উক্ত বেংকৰ লগত মোৰ কোনো ধৰণৰ লেনদেন তথা যোগাযোগ হোৱা নাই। আজি 13/5/2025 ইংৰাজী তাৰিখে বন্ধন বেংকৰ নলবাৰী শাখালৈ গৈ মোৰ একাউণ্টৰ ষ্টেটমেণ্টটো উলিয়াই চাই দেখিলো যে মোৰ অজ্ঞাতে কোনো দুষ্ট চক্ৰই মোৰ একাউণ্টত বহু টকাৰ লেনদেন কৰি আছে। কিন্তু ইয়াৰ কোনো তথ্য মোৰ মোবাইলত অহা নাই। কাৰণ একাউণ্টত সংলগ্ন হৈ থকা মোৰ মোবাইল নম্বৰ আৰু ইমেইল আইডিৰ পৰিৱৰ্তে অন্য নম্বৰ আৰু ইমেইল আইডিহে সংলগ্ন হৈ থকা পৰিলক্ষিত হয়। যিটো কৰিবলৈ মই নলবাৰী শাখাৰ বন্ধন বেংকৰ কৰ্তৃপক্ষ নাইবা শাখা প্ৰবন্ধক শ্ৰী হেমেন শৰ্মা কোনো ধৰণৰ অনুমতি প্ৰদান কৰা নাছিলো। উল্লেখযোগ্য যে মোৰ অজ্ঞাতে উপৰোক্ত পদকীয়াগণে দুষ্ট চক্ৰৰ লগ লাগি মোৰ একাউণ্টটো অপব্যৱহাৰ কৰাৰ লগতে মোক ঠগ প্ৰবঞ্চনা কৰাৰ উপৰিও মোক বিশ্বাস ভংগ কৰিছে আৰু চৰকাৰক ৰাজহ কৰ ফাঁকি দিছে। গতিকে so I have no access to the system of the bank because I am not a bank employee. So my role, my lord, only is that my lord, I introduce the bank official with the informant. So I have collected, my lord, even if my lord, allegation my lord, believes to be true, my lord, but I have introduced them and I have collected the documents. So regarding my lord, system, my lord, I have no access. So 53 days, my lord, 53 days and so, my lord,
So it depends on what is the progress of the investigation.
Yes, my lord. And I have never been, my lord, interrogated, my lord, thereafter. Initially, my police custody was taken Thereafter, my statement recorded, I have fully cooperated, and thereafter, my lord, police never sought my lord, police custody. Neither inquired me inside the jail. So, perhaps, my lord, my further custodial detention may not be necessary, my lord. And lordship may kindly see the forwarding report.
Where is the forwarding?
Forwarding report, page 21, my lord. Grounds of arrest. Yes, my lord. On so and so, informant, pornography laws and so and so. FIR name accused Das has asked me to open loan account in Bandhan Bank, Nalbari branch in December so and so. Accordingly, one Minmoy Kolita of Bandhan Bank came and took his signature in blank forms and various documents. But his loan was cancelled, and in May 2025, he went to the branch and took his account statement and saw crores of transactions made by his account by changing the registered phone number without his consent. He suspect Konkon Das, Konkon Das and Bandhan Bank official, mainly branch manager Hemant Sharma, involved in the conspiracy. I am not the bank employee.
Yes.
So, my lord, accused name has been mentioned by all the victims to have instigated them to open the bank account. So, my lord, only on suspicion, my lord. But the facts is that, my lord, I am not bank employee, my lord. So I have no access, and 53 days for my lord, 316(5) will not be applicable in my case. My lord, considering the length of detention.
Yes, Mr.
Yes, Lordship, just to clarify one thing, Lordship, the present petitioner in item number 64, this is in relation to Musalpur PS case 37/25. What is happened, Lordship? This is a series of cases that are tagged together, Lordship. There are
Different cases.
Yes,
Okay.
two cases are in question, Lordship. One is 37 and one is 38. This case is related to 37, Lordship.
Okay.
Musalpur 37.
I have stated that bail application 2077. I am moving 2077. 207 relates to 38.
Oh, I'm sorry.
2077 relates to 38.
Then I will make submission on 38 also. Yes, 38 Lordship. Here Lordship, what has happened? If Lordship kindly comes to the other.
No, not separately.
Okay.
Otherwise, it will create confusion.
Thank you. And Lordship, if Lordship.
Because his case is that he is not a bank employee.
Yes.
He introduced the informant to the bank employee.
Yes.
And took his bank documents, PAN cards, and there is an accusation that he manipulated and he connived with the other accused.
Also, this submission which I am going to make, it will involve every one of them.
Okay.
Yes. So, Lordship, what has happened, Lordship? Lordship, can you take up the FIR? Lordship has already seen at page 16. This involves, Lordship, mule accounts.
What account?
Mule account, Lordship.
Somebody else's account is used.
Yes, for illegal means, Lordship, that is, the priority is, Lordship, gambling money, Lordship. And it is an racket, Lordship, that is going internationally, Lordship. Now, what has happened, Lordship, as per the FIR, some of the informant, Lordship, they have filed this FIR, Lordship, before the concerned police station, and thereafter, Lordship, when inquiry was done, 5 mule accounts were detected, Lordship. And all these 5 mule accounts relates to the same branch of the Bandhan Bank, Lordship.
Okay.
And Lordship, thereafter, Lordship, in these 5 accounts, a total of, Lordship, if I just give a lump sum, Lordship, around 13 to 14 crores of money has been transacted, Lordship.
Okay.
And Lordship, the investigation is at a very nascent stage. And what has happened, Lordship, is that it is suspected that there are other mule accounts also, Lordship, and which is under investigation. There are also a number of persons who are yet to be arrested, including bank officials and other CSP owners and other agents also, Lordship, and brokers also, Lordship. Now, coming to the facts of the case, Lordship, the branch manager of the bank, Lordship, that is Hemant Sharma, that is in item number 40. He is the prime accused along with the present petitioner, Lordship. Just I'm trying to lay out the plot, Lordship.
Yes, yes.
Now, what has happened, Lordship? This present petitioner, Konkon Das, he takes hold of innocent persons who are in need of money or loan, and then he introduces, he asks them that to give them their credentials, including documents, and thereafter they are not asked to go into the bank. He opens a bank account in Bandhan Bank with the active cooperation of the manager and other co-accused. Thereafter, Lordship, those accounts are used for illegal means, as I have already stated. What has happened, Lordship? All those CDR analysis has been done. There is constant touch of him with the manager, Lordship. That apart, Lordship, this when the account is opened, Lordship, the phone number that is given, it is later on changed to some other phone numbers. That too without the permission of the
account holder.
Lordship, and they are also not asked to go and sign documents in the bank. It is a mandatory provision, Lordship. For change of phone number or address, one has to mandatorily appear before the bank officer and sign some documents. This is not done here, including email ID also, Lordship. And also the magnitude of the crime is, Lordship, that a normal account, when it is opened, Lordship, if there is a transaction of above 1 crore in a single payment, the information has to be given to the RBI by the manager, which has not been done in this case, Lordship. And Lordship, that is referred to as no suspicious transaction report, STR, suspicious transaction report. That has to be given by the manager to the RBI, Lordship, when there is a transaction of 1 crore and above, Lordship, in a single transaction. That was not done in the present case. So, Lordship, going on by the magnitude of the crime, and it has been ascertained by the investigation so far, Lordship, that he has received lakhs of rupees as money, Lordship. Payment from
the present petitioner.
Present petitioner, Lordship.
From whom?
From the manager. They have distributed him amongst themselves, Lordship. There is a screenshot of the mobile Google Pay, Lordship, amount 50,000. One screenshot has been available in the case diary. That has been available by the present petitioner. So that is his involvement, Lordship.
You flag mark that.
Yes, I have flag mark. And Lordship, he has, and Lordship, one other case is pending against it, that is 37.
In today itself.
Yes, yes,
Yes,
yes.
Item 63, my lord.
Here, Lordship will find, Lordship kindly comes to the FIR, page 18.
It is a different case.
A different case. But Lordship, premise is different, same, Lordship, because allegation is same, and one of the account holders whose account was used as a mule account, he committed suicide, Lordship, because he was served a notice by the Rajasthan police for illegal cyber activity. That, Lordship, will find at page Lordship 23. For a moment, Lordship.
23 of which item?
Item 64. Oh, 63. 37. Oh. 60? We'll put 37.
2079, 2079.
2079.
2079. Bail application 2079.
Which page?
Lordship will find it at page 23. This is Lordship submission of inquiry report. This found it. 23.
Yes.
Yes, Lordship will kindly see submission of inquiry report.
With reference to the subject cited above, I would like to inform you that a written complaint was received from so-and-so and complaint was filed by Anjan Das. He is the original informant lordship. His brother had committed suicide. So-and-so, according to the complaint petition, his mother, Ukha Haloi, saw her elder son, Dipankar Das, committing suicide in the garage of their house this morning and informed the neighbors. His elder brother had been mentally overwhelmed for the past few days as the person mentioned in the petition, namely Konkon Das, present petitioner, had collected PAN card, Aadhaar card, voter ID from the complainant, promising to give him a loan from Nalbari Bandhan Bank branch. But on 7/5/25, the police personnel of Cyber PSC Ganganagar, Rajasthan, came and informed that a large sum of money has been transacted through his account. Accordingly, the complainant checked the bank statement and was shocked. The complainant also learned that through the bank that someone had changed his bank account mobile number without his knowledge. In this regard, they had already lodged a complaint at Nalbari PS on 9/5/25. After that incident, the complainant's brother broke down and finally chose the extreme decision. During the preliminary inquiry, the complainant and other witnesses were examined, and also after investigating various aspects, it came to light that Konkon Das, so-and-so, and Hemant Sharma, he is the branch manager of Nalbari Bandhan Bank, changed the complainant's mobile number so-and-so in his bank account without his knowledge, and the changed mobile number is so-and-so, to which a large amount of money transacted to his bank account. So 37 lakhs relates to the his suspect.
Okay. You have separate case diaries.
Yes.
Both case diaries are available.
Yes.
Well, this case registered under section 108 of BNS, madam. So, if your lordship see the FIR, madam, page 21, madam. Page 21 vernacular, madam.
Yes.
Well, here, madam, the FIR petitioner is the FIR name accused, madam. উপরোক্ত ঠিকানার ব্যক্তিজনে নলবাড়ির বন্ধন ব্যাংকর পরা লোন
What is your submission in this case? Same submission.
108, whether 108 is applicable, I am no way connected, I have, they are villagers of the same village, I am the village of the belonging to the same village. So, they approach me that if I can arrange for a loan for them, what bank officials do, I am not aware, because I have no access to the system. My only submission is that, I have tried to help them. But what bank officials do, for that I may not be held responsible, because I have no access to the, I cannot sense the email ID, mobile number in the KYC, I cannot sense. I am behind the bar since last 53 days. Considering that, only detention period.
Oh, this is only under 108.
108, only 108. Whether that constitutes
So this is a different
suicide.
Different case.
Different case.
It has to be considered
no
on.
relation with that matter.
I will hand over the case diary. Lordship will kindly go through the statement 105 flegma. Rest I leave it to you, Lordship.
Well, some police officials came and called him to the police station for the purpose of interrogation. He was not arrested.
Mosalpur PS case number 37/2025 is registered under only 108. Only 108. Okay. And what are other connected matters?
I am appearing in item number 42, my lord. Well, his name is Hassan Basri, my lord. Hassan Basri, my lord. Well, I am an employee of this person, my lord.
Who's?
My lord, this Konkon Das, my lord. And I am behind
what Kankan does what he do?
Well, I am an employee of Konkon Das, my lord.
What do you do?
My lord, I have
specifically stated, my lord, categorically in page 2, my lord, that the petitioner begs to state that the accused person is a businessman as well as a casual loan recovery agent, and he works under him as a loan recovery agent.
Konkan Das is a loan recovery
Yes,
agent.
yes. And I am behind the bar for 44 days, my lord. And my lord, so far 3165 is concerned, my lord. Although the punishment is, my lord, up to life, my lord, it is with regard to the public servant, my lord.
Not only public servant,
But,
bankers, agent, others.
yes, my lord. And other two sections of the 66C and 66D of the IT Act, my lord, I think it's a 3 years punishment, my lord. Bailable, my lord. And my lord, second part, my lord, and my learned friend has submitted, my lord, crores of rupees were involved, my lord. But from the forwarding report, my lord, it says, my lord, there is a suspected transaction of rupees only 12 lakhs is concerned.
Where?
My lord, page 22 of my petition.
12 lakhs where in your account?
My lord, it says, my lord, as shown by the accused Kankan Das, suspected transaction of 12 lakhs concerning payment of mule accounts. My lord, that is at page 22, my lord, grounds of arrest, serial number 3, my lord. And one more, my lord, ground that has been stated, my lord, in the forwarding report. It says, my lord, there is a CDR link between Hassan Basri, that is the petitioner before your lordship, with that Kankan Das, my lord. That is, my lord, ground of arrest number 2, my lord. I have been in the police remand, my lord, for 5 days, my lord.
Your date of arrest is?
My date of arrest is, my lord, 01/06/25. And today is exactly, my lord, 52 days, my lord. In fact, I was arrested on 31, my lord, previous month, but I was forwarded on 1/6, my lord. So it will be around 53 days, my lord, exactly.
Yes. What is your submission?
Yes, Lordship, here, Lordship will kindly take up, along with this, item 69.
How many connected cases are there?
These are related, Lordship. Both of them are brother. Allegation is same. They are both CSP owner. The allegation is same.
69 to more outline point. No. So far, my lord, my friend is referring to item number 69, my lord. 69, my lord, Ibrahim, my lord. He is the brother of Hassan Basri, my lord. And he had a CSP.
You are also CSP owner?
Yes, my lord. That is Ibrahim, my lord. Item number 69.
No, in item number this.
Okay. My lord, actually, the owner.
Hassan Basri is also a CSP owner.
No, my lord. Actually, my brother is the owner, my lord. Legally, he is the owner, my lord.
Okay.
Ibrahim, my lord. That is item number 69. And that is, my lord, there is an anticipatory bail, my lord. No interim was done, my lord.
69 is AB.
AB, my lord.
Okay.
Even though Lordship, this is AB Lordship, allegation is same, so I have asked Lordship to take up the same together. What has happened, Lordship, here, both of them are, Ibrahim bin Adham is the owner of the CSP, but both of them looks after the business, Lordship. So allegation, Lordship, as Lordship has already seen in the forwarding also, Lordship, they have, Lordship, received and as well as Lordship transacted a large sum of money, around 12 lakhs so far, Lordship. And they have close links with one person by the name of Sofikul Islam, who is still under investigation, Lordship, and is absconding, Lordship. His interrogation is very much necessary, Lordship, to unearth the whole conspiracy. His name appears everywhere, Lordship, this Sofikul Islam, and they are in close touch with these two brothers, Lordship. And their CSP that has been used as Lordship is in the forwarding for this illegal money, Lordship. is the allegation. If Lordship kindly comes to the next page, page 23. Forwarding next page. So let's see production of police remanded accused person. Here also will find during the police remanded period, it is revealed that accused Hassan Basri's mobile number was analyzed. During the analysis, it was found that he had frequent contacts with Konkon Medhi, Konkon Das. It has also come to light that Hassan Basri invited one Sophie named so-and-so to Jalukbari and so-and-so introduced him to Konkon Medhi. At that place, Sophie told Hassan Basri that he will provide money from time to time and he will have to send the money to Konkon so-and-so. Hassan Basri will be a good commission in return. In addition, Sophie said that the money he paid was the money of a game. Accordingly, Sophie came to Hassan Basri's CSP at various times and paid him about 8 to 9 lakhs to send to Konkon Medhi, Konkon Das, which is also found in the bank transaction. That is the sum of the allegation. And from the statement of the other co-accused also, it has been found that so far they have received a large sum of commission in that regard also. Just verify. In a number of times they have received commission lordship, ranging from 5,000 to 2,000 lordship in a number of transaction. It is the involvement of.
But they were told that this is a commission in respect of some game.
They knew lordship that it is an illegal operation lordship because Konkon Medhi was also involved in that case lordship. This is a chain of lordship. This is a chain conspiracy lordship. You understand? Because each person is linked with the other. Now the main accused person, one of the main accused, Sophie Gali, that I have shown lordship, he is still absconding, and they have close links with the Sophie Gali. And lordship will also see that Hassan Basri is EA, but the other lordship, Ibrahim bin Adham, that is AB lordship. So custodial interrogation is very much necessary lordship to unearth the whole conspiracy.
Okay.
So that is my submission in respect to these two cases.
So far that item number 42 is concerned, my lord, I have submitted, my lord, police has taken me remand, my lord. My lord, there was a second, my lord, forwarding report, my lord, page 23, my lord. There it is specifically stated, my lord. Accordingly, Sophie came to Hassan Basri's CSP at various times and paid him rupees 8 to 9 lakhs to send to Konkon Medhi, my lord. That may be noted. My friend also submitted that.
Okay. Any other connected matter?
Yes.
How many connected matters are there?
One more lordship person is there.
Yes.
Yes.
40.
Main is for the last lordship. Last one is the best lordship.
Okay. 40.
My lord, fortunately or unfortunately, I'm the branch manager, my lord.
You are on interim.
Yeah, I am on it. I'll come to the FIR, my lord. The huge amount of money maybe, my lord. But the allegation against me, so far as the FIR is concerned, I'll be very frantic, my lord. Lordship, may kindly have a look. It begins at page 11, my lord. My lord, there are...
You are Hemen Sharma.
I'm Hemen, I'm the branch manager, my lord.
Okay.
Branch manager, my lord. I am on interim, and there was an allegation that I did not cooperate. Even, my lord, I cooperated to the extent that I appeared 3 times before them. My mobile and everything, entire seizure list is there with me. I provided all sort of cooperation, my lord. Now, my lord, the contents of the affair, my lord. There are 3 persons named, my lord, and the allegations are. Respectful submission is that I have to read the in totality, my lord. It will be clear. I have a permanent grocery shop at so-and-so.
Page number?
My lord, 11, my lord.
Yes.
Allegations are against 1 and 3, specific, my lord. Respectful submission is that I am a permanent grocery shop at Abhayapuri, so-and-so. It goes on, my lord. When the accused number 1, this Kongon Das, not me, my lord, came to my shop, I got introduced with him, and the accused number 1 introduced himself to be an employee of the bank. Some days later, that the accused number 1 came to my shop. I'm not him, my lord, and opened a current account in my name and told me about sanctioning a business loan. He called the accused number 3, different man, my lord, not me. An employee of the Bandhan Bank procured so-and-so, so it goes on, my lord. Of my signature several forms, blank papers, goes on and on, my lord, in the Nalbari branch of Bandhan Bank, with the assurance of sanctioning a business loan. But it is a matter of displeasure that they were unable to get the loan sanctioned. Thereafter, I had neither made any transaction nor any communication with the said bank. On 13/5/25, I went to the Nalbari branch of the Bandhan Bank, procured statement of my account, and could notice that without my knowledge, some miscreants transacted huge sum of money through my account. But no information regarding the same is available in my mobile. This is my allegation against me starts, my lord. It has been found that some other mobile number and email ID instead of my contact email ID were connected to my account, regarding which I had never permitted the authority of Bandhan Bank, Nalbari branch, or its branch manager, Hemant Sharma. I'll complete it, my lord, then I'll place the, my lord, factual matrix. It is to be stated that without my knowledge, the aforesaid accused person, in connivance with some miscreants, have cheated me and breached my trust, apart from misutilizing my account, and have evaded revenue of the government. As such, your honor may be pleased to investigate into the said incident, arrest the accused person, and goes on and on, my lord. Here, my lord, the factual background, it is not on record, my lord. This particular account, to my head, from my head office, this is not on record, my lord, not in my application also. As has been told to me, my junior friend, that, my lord, there is an, my lord, with all respect, written communication or oral communication, that, my lord, whether this account, my lord, is dubious, my lord. Then, my lord, at the direction of the superior, my lord, this bank account was closed. And after closure, my lord, this affair has been lost. Allegation against me is this, that, my lord, I was either conniving or did individually, my lord, with all respect, or we in collusion with others, my lord, with all respect, my lord, ID was changed. That is not the fact, my lord. That is why I was granted interim, my lord. It was applied by the first informant himself and allowed by my junior assistant manager. I had no role to play to change the numbers, my lord. If some huge amount is deposited, then the first informant should also be roped in. Kindly see, my lord. Let me come to allegation against the bank manager is this, my lord. Again, I am repeating page 12. First, second, third, fourth, fifth, sixth line, my lord. It begins. Fifth line, it begins, my lord. It has been found that some other mobile number and email ID instead of my contact and email ID were connected to my account, regarding which I had never permitted the authority of the Bandhan Bank Nalbari branch or its manager Hemant Sharma. This is the allegation against me, my lord. Now, Lordship would kindly, that is why interim was granted, my lord. Lordship would kindly have a look at page 21, my lord. This was applied by him with all respect, my lord, that his ID number and, my lord, with all respect, my lord, mobile number should be changed, and thereafter it was changed. It occurs the new mobile number, my lord, page 21, mobile number 600 so and so, new number. Thereafter it continues, my lord. And the third page, at his request, he is in connivance, my lord, with all respect, my lord. He allowed it, made a prayer so that it is changed. Now I come to page 23. My lord, email has been changed. That is at page 23, my lord. My lord, ID established so and so, P so and so, new. Email changed at his behest, my lord. Next page, his signature, Dhiras, sorry, my lord. Pranav Bayon, he is the first informant, his signature, and this was allowed by. He was introduced by Dhiras Kolita, accused in item number 8, and identity allowed by assistant branch manager, not me, my lord, assistant branch manager lekha ase. He is assistant branch manager, my lord, page 24. Branch said, assistant branch said. It is the signature of the assistant branch said, my lord. So far as I am concerned, my lord. Because both designations are there, branch said and assistant branch said, my lord.
Who is the assistant branch head?
My lord, name, my lord, if necessary, we'll file an assistant branch head has signed it, my lord, at page 24.
No,
this may
but
be on record.
You must be knowing his.
Yes, definitely, my lord. At the moment, I may not be knowing, but this is the signature of the assistant branch head. This is the factual matrix, my lord. My lord, there may be huge transaction in different accounts. That's a different matter. If in this account there is a huge transaction, my lord, even that I will add, my lord, that my higher ups from Bombay or Delhi, my lord, ask me as to whether there is the dubious transactions are there in the bank. Then we verified and found it, with all respect, my lord, and the bank account was closed, my lord, shut down.
Where is that?
Exactly, my lord. If necessary, give us 2 days time, my lord, we will produce everything, my lord. Only 2 days. Thereafter, if there are materials, lordship would reject it. And what would be the section of law attributed? Kali, law is very clear, my lord. It may be a huge sum of money or 1 rupee. Crime is a crime, my lord. When IT Act is there, my lord, what are the sections of law attributed, my lord? May I just place it, my lord, with all respect, my lord. Let us come to the, my lord, head note. Sections of law attributed are, my lord, because he is a banker, with all respect.
No, you want to submit additional affidavit. You have to be clear.
Yes, sure. Not way. My junior friend has instructed me to say like this, my lord. That is why I am submitting.
But that has to be on record.
My lord, he prays for, of course, he is praying, my lord, with the lordship 7 days, my lord. We procure the documents. No, thereafter, lordship would reject it if it doesn't tell him, my lord. The heavens will not fall. I am on interim. I appear.
So respectfully, Lordship, may I inquire on what purpose it is sought to be filed?
My lord, that in this account, there was a query from my higher ups, with all respect, my lord, that whether the account is dubious or not. I informed.
No, that is one of the submission by additional public prosecutor in other case, that where there is suspicious transaction in a particular account.
My lord,
it is the duty of the bank manager to inform the RBI.
Your lordship is very, very correct, but it has to come to my knowledge.
But what is happening in your bank, you must be knowing. You have
my
to
lord,
know.
that is, my lord, that can be a dereliction of duty, my lord. When in the information came to me that the account is dubious, whether it is closed or not at my behest, my lord. There is no illegal transaction that money was taken out. Let me file an affidavit if lordship feels that I have committed a crime. Reject it, my lord. But mere presumption, my lord, huge sum. The FIR does not say what sum. Can it happen, my lord?
No, FIR may not contain everything.
No, I'm not saying that. In my house, something is stolen, my lord. I may not know, my lord, but whatever is stolen, huge amount of money.
Okay, you file additional affidavit.
My lord, kindly give me 7 days time, my lord, as my junior friend has suggested, my lord. My lord, thereafter, lordship would reject it if your lordship finds that I am also into criminality. And so far as the IT Act sections are concerned, my lord, law is very clear. When IT Act is applicable, my lord, IPC or now, my lord, BNS cannot be applicable. This dignity is there, my lord. Law is clear. And unfortunately, one has to do one's homework, my lord, prosecution. The sections of law attributed to the case. So far as IT Act is concerned, my lord, if I have manipulated ED, these are the allegations against the banker, my lord. If ED and mobile number changed everything, my lord, then it would be, my lord, all bailable offenses because 77 is operating.
But 3165 is there.
No. When, my lord, the dignity says, my lord, when offenses are committed under the IT Act, as well as any other penal law, if there is an overriding provision, 78 is there overriding. I need not have to read it in the affidavit. I'll quote it, my lord. Then it will be a bailable offense, my lord. I'm not into that, my lord. Whether I was told by my higher ups that it is dubious or not, whether I closed it or not, that I'll place before your lordships, my lord. And thereafter, if lordship finds that I am also in connivance with other criminals, my lord, lordship will reject it, my lord. Give me at least breathing time for 7 days, my lord. I'll file an affidavit, thereafter lordship would consider, my lord.
Yes, Mr. Sharma. Regarding his prayer for filing an affidavit.
Lordship, if Lordship allows me to submit, Lordship, I can clarify regarding all aspects, Lordship.
No, let him submit the affidavit. Do you need his custodial interrogation now? We'll direct him to appear before you.
My lord. And on which date I appeared, my lord, there was an earlier order, right in the order sheet, my lord, I did not cooperate. May I just read it before your lordship? This is not the way. You hold me up properly, my lord. I appeared before the my lordship, kindly turn the page, 1 page, my lord, backwards, my lord. There is an order, may I just read it, my lord? Somebody dislikes me, that's a different matter. But how can you do that? At least law has to follow, my lord. Order to sound. Yeah, I got it.
How many anticipated? One AB is there. That AB number 655. 1 KB.
1 BA is there, Lord Ship.
8 is BA.
Mayor Lordship, I'm sorry, man.
Yes.
Mayor Lordship, look at the order dated 2/6/25.
Yes.
2/6/25. Lordship has found the order, my lord. With all
Yes.
respect, my lord.
Yes.
Their first line, second, sorry, first paragraph, second paragraph, third paragraph gone, my lord. Fourth paragraph. The petitioner is directed to cooperate with the investigating officer because I was on interim bail. I already cooperated. It is made clear. If on the next date any such report comes from the investigating, the court may take adverse view against the present petitioner. There is a report that I was not cooperating. But in factually, my lord, I appeared before the investigating officer, that is on record, my lord, on 16/5/25 prior to getting pre-arrest bail. Thereafter, I obtained pre-arrest bail. And I was granted the, my lord, I appeared before the investigating officer on 23/5, thereafter again on 10/6, and thereafter, my lord, on 27/5, 27/5, 29/5, 35, 35, 35, on 5 days, they came to my office, my lord, seized materials, my mobile phone was seized, and that's all the list are with me.
What is your connection with Konkon?
That, my lord, even in the affidavit, I'll specify, my lord, that I do not know who Konkon Das is at the moment. No, I must be knowing, my lord. That query would come up. How can you say that?
If there is something in the case diary.
Yes, my lord. My lord, let my affidavit come, whether I did that or not, my lord.
Okay.
So far as I am concerned, my lord.
In item number 40, heard Mr. B.K. Mahajan, learned counsel for the petitioner, also heard Mr. B. Sharma, learned additional public prosecutor. During the course of submissions of learned counsel for the petitioner, a query was posed. On a query posed by this court, learned counsel for the petitioner sought leave of this court to file an additional affidavit to bring on record some additional facts which have a bearing in consideration of this instant of this bail application. Though learned additional public prosecutor has opposed the said prayer and has submitted that custodial interrogation of the present petitioner is necessary for fair investigation of this case. However, considering the facts and circumstances of this case in its entirety, time for filing additional affidavit, as prayed for by the learned counsel for the petitioner, is hereby granted. Let this case be listed. When will you?
Kindly 7 days. Seven, my lord, with all respect, 7 days, my lord.
30. Let this case be listed again on 30th July 2025. The interim bail granted to the petitioner shall continue till next date. And
Oblige, my lord. Oblige.
And one more case is there.
My lord.
Number 8.
Highly obliged.
Dhiraj Kalita.
Yes.
What is your case?
Yes. In this case, my lord, I was arrested on 6/6/25 and 47 days behind the bar.
47 days.
Yes.
In
as of today.
PS case number 38.
Yes.
Okay.
Now, my lord, kindly see the forwarding report. Yes.
Your date of arrest is?
6/6/25.
Yes.
Now I'll kindly see forwarding report, page 19.
You introduced.
Yes, I just complete the rest of task. I was in police custody, 5 days police custody initially. On the date of arrest, I was allowed to police custody, and on 11/6, my lord, I go for judicial custody. In the initial forwarding report, my lord, in third para, my lord, my allegation is Konkon Modahi transfer money to Dhiras Korita. This is as an simple evidence of Dhiras Korita involvement in this incident. Above the ground of arrest, my lord. This is the line.
What is your submission?
Submission is, my lord,
Period of detention 1.
long length of
Any other submission?
any other involvement, my lord. In case of involvement, my lord, can we see? Yes, another forwarding report, page 21. Can we see, my lord, during the police remand period, that para in last portion, my lord.
Yes.
Hemen Sharma conspired to get him to sign the form when Pranab Bayan went to their bank one day before 13th Chocho. The rest of task of the form was completed by Dhiras Kulita. I just completed that account. The informant account was created by me, my lord. It is my job, my lord, in the bank.
Yes.
It is only allegation.
In a lump sum, lordship.
Unless he knows
Yes.
why this.
Yes.
No. If he does not know
Yes.
that there is a
Yes.
intention of the prime accused to deceive that.
Yes.
He is an employee of the bank. He may be performing his duty bona fidely. Is there anything in the case which indicates that he knew about the conspiracy?
21 from.
Yes.
It's 21, lordship, second paragraph. During the police remanded period, it has been revealed that accused Dhiras Korita mobile phone number so-and-so and bank account so-and-so was checked and analysis. During the check, it was found that 1,50,000 had been received from accused Konkon Methi, alias Konkon Das.
Okay.
This frequent contact has been found with Konkon Mathur, Konkon Das. During the interrogation, initially it is also revealed that Pranab Bank, that is the customer, lordship, request form was signed on so-and-so without appearing at Pranab Bank's shop in Pathiabadi on the instruction of the bank manager. However, Dhiras Korita did not come to Pranab Bank's shop on that day, did not get him to sign the form. Instead, Hemen Sharma conspired to get him to sign the form when Pranab Bank went to bank one day. So also it's a chain, every one of them is involved, and including other bank officials also that are not under investigation right now also. And Lordship will kindly see paragraph number 3 for a moment of his petition, Lordship. In bold letters, Lordship, he has shifted the blame to Hemen Sharma. Lordship, kindly. Main culprit is Hemen Sharma. It is not hard to miss.
No, but generally in bank,
Lordship.
the customers are normally asked to put their signatures in blank forms.
Yes.
That is the practice.
But they have to be in the bank also. They have to be present in the bank.
Yes.
And thereafter, we have to.
And manager used to entrust
Yes.
some other employee to fill up the forms. He's saying that I was just obeying the directions of the manager.
Then why got you 1 lakh?
Okay, okay.
What is his
That
relationship?
is there in the case diary.
Yes, and what is the relationship of him with Concordance? He is not an employee of the bank. He is not a customer. Who is Concordance? Why are they all associated with Concordance? That is the main question, Lordship. Why
Yes.
should a third person be so much in contact with all these curiae? And also, Lordship, in paragraph number 4 also, Lordship, they have stated, it is stated that the accused petitioner never did any such activities which are against the law and create disturbance and the accused unnecessarily involved with the crime. He is just an employee and doing the task as per directions from Dharma. So, Lordship, all this shifting of blame is going on.
Okay.
That is very clear on the forwarding report.
I'll go through the case diary. Anticipatory anticipatory bail application number, item number 8.
The bail application,
Oh, it is a bail application.
47 days was on to
All bail application, that is item number 64, 8, 63, and 42. Counselor naam separately likhibo sabate. PP is B Sharma. Heard so and so list this case for delivery of orders on 4th of August. And in anticipatory bail application number 69, this I will pass orders in chamber today. You give me the case diary.
Yes. Who case there? Who case there?
Yes, one is 37 and 38. 38 is the main case. 37 is only against Concon. Whether you need the case diary of 37, 38 back before filing of the affidavit, or can it be retained till 4th?
So I'll try and retain, Lordship, if possible, Lordship.
Okay, then it will be with me.
Yes, Lordship.
You give the case diary.
Lordship.
Okay. Clear, Hussein Munmun? Item number? Yes, item number 65.
Right, please, Lordship. My lord, I have been in jail since 23/5/2025. My lord, almost 60 days, 2 months is over, my lord. Can you see the FIR?
How many days you are behind the bars? Exact.
23/5/2025, I think today is 58 days, 59 days.
59 days. 59 days today, my lord.
What is the offense?
My lord, offense 3184, 3162, 3182, cheating, criminal breach of trust. All the co-accused have been granted bail, my lord. Well,
This is also one kind of, my lord, that mule account, my lord, and
Mule account.
Mule account, my lord. Otherwise, materials are there, but only, my lord, length of detention, my lord, 60 days of.
But this offense is 60 days of the offense.
60 days. All the co-accused have been granted bail. my
Where is the bail order? Give one
So
bail
far,
order.
one person is concerned, my lord was pleased to grant interim anticipatory bail. These are the orders, my lord. One is on interim, my lord. But my lord, kindly see the FIR page 16, my lord.
Yes. What is your name?
My name is Namaran Pitam Hati Borwa. My lord, there is no allegation against me, my lord. Only Telegram channel. I am using the Telegram channel, but I do not install the Telegram channel itself. Kindly see, I am Pitam Hati Borwa. At page 15, number 1. At page 16, kindly see, page 16, very important, my lord.
During preliminary interrogation, it was revealed that the accused persons were operating multiple fraudulent current bank accounts of various banks, including Northeast Small Finance Bank, as mule accounts to facilitate the illegal transactions. They often use suspected groups of the messaging applications Telegram for asking. My lord, my telephone was seized, my lord. I did not install the Telegram channel. Second line important, my lord. Accused Ibrahim Ali disclosed that he was acting under the instructions from the following persons. This is Hedayatullah. My lord, both these Ibrahim Ali and Hedayatullah, I do not know them. And both these persons has got the bail order, my lord, on 14 and 15, my lord. 14 and 15th of July. I have submitted the bail order copy. My lord, there is no specific allegations against me.
Yes. Period of detention. Do you need his further?
60 days offense otherwise.
So today is 58 day.
59 days.
59 days.
What is your submission?
Dishonestly sitting, these are there, malad,
Heard.
collecting money.
Heard, Mr.
And various persons involved.
Heard, Mr. What is your name?
S.S. Goswami.
S.S. Goswami, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Shri Pritam Hathi Borwa, who has been detained behind the bars since 23/5/2025 within bracket for last 59 days in connection with Bishwanath Charali PS case number 105/2025 under section 61 within bracket 2/318 within bracket 4/316 within bracket 2/318 within bracket 2 of BNS read with section 43/66C/66D of the IT Act. The gist of accusation in this case is that on 23/5/2025, one Rajdeep Newar, SI of police, had lodged an FIR in the before the officer in charge of Bishwanath Sareli police station, inter alia alleging that on receipt of an information through reliable source regarding a network of culprits involved in illegal money transaction in various parts of Assam, and a search team was constituted, and accordingly the persons named in the FIR, including the present petitioner, were apprehended on suspicion of their involvement in illegal financial transaction network. Learned counsel for the petitioner has submitted that though the accusation has been made in the FIR against the petitioner that he is also involved in illegal financial transaction and also involved in using messaging application within inverted comma telegram for executing such illegal transaction, comma, however, comma, the petitioner does not have any telegram message, telegram messaging application in his mobile phone. He further submits that the mobile phone of the petitioner has already been seized. He has also submitted that in the meanwhile, some of the co-accused have all some of the co-accused against whom accusation has been made in the FIR and they have been shown as main accused in the offense alleged in the FIR, like Hedayatullah and Ibrahim Ali, have already been granted bail by a coordinate bench of this court in bail application number 2174/2025 as well as 2215/2025 respectively. Learned counsel for the petitioner has submitted that the maximum statutory period of detention under section 487 of the BNSS for which the petitioner may be detained behind the bars in connection with the offences involved in this case is only 60 days, whereas as on date he has already completed 59 days behind the bars. Stop. Learned counsel for the petitioner, thus submits that considering the period of detention undergone, he may be allowed to go on bail. It is also submitted that the petitioner is ready to cooperate in the investigation if he is allowed to go on bail. On the other hand, learned additional public prosecutor has produced the case diary of Bishanath Cheryl EPS case number 105/2025 and has submitted that there are sufficient incriminating materials in the case diary against the present petitioner. He, however, has fairly submitted that the offense involved in this case, under offense involved in this case, an accused may be detained behind the bars, during the period of investigation, for only 60 days, whereas the petitioner has already completed 59 days behind under detention. Stop. I have considered the submissions made by learned counsel for both the sides. Though sufficient incriminating materials are there against the petitioner in the case diary, however, considering the period of detention undergone by the petitioner within 59 days, and also considering the fact that the offense involved in this case entails maximum detention during investigation for a period of 60 days only, the petitioner is allowed to go on bail. Stop. Accordingly, no, the further custodial detention of the petitioner may not be necessary. Accordingly, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate Bishwanath with following conditions, number 1 and number 2. Send back the case diary. This bail application is accordingly disposed of.
Item 66.
Thank you. Thank you. Take pleasure option.
Yes.
Regular bail application, my lord, 21 days in custody. 5 kg of beef was found in my hotel, my lord. Their allegation is it was beef, my lord. Our contention is that it was buffalo meat, my lord. We have also annexed the documents in support of our contention.
Which document?
Document, my lord, will kindly come to page 20, my lord. Continuation, page 20.
Yes.
Page 20 is a receipt, my lord, issued by Indian Agro Foods, my lord, in the name of my hotel, my lord, Bismillah Hotel, my lord. And now, my lord, will kindly come to page 21. Continuation, my lord. Here, your lordship will find, my lord, this is buffalo bone-in meat. And even page 22 is the e-way bill, my lord, that is for buffalo meat, my lord. So now, my lord, the investigation will reveal, my lord. If it's buffalo meat, my lord, this case will end up in a final report. If it is beef, my lord, I will go and face the trial, my lord. But since everything has been seized, my lord, perhaps my further detention is not required, my lord.
Yes.
My lord, that FSL report not yet received, my lord, but accused herself, my lord, stated that she is continuing with business and these are buffalo. As per the statement of the
Hello.
No. And statement of the other witnesses, my lord, nearby witnesses, they were in that hotel, my lord. If it is found, my lord.
Heard Mr. S. Nawaz, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Afruza Khatun, who has been detained behind the bars for since
2/7/2025. Arrested on
1/7/2025 within bracket for last 21 days in connection with Bosaigaon PS case number 87/2025 under section 299/325/61 within bracket 2 of BNS read with section 13 within bracket 1 of the Assam Cattle Preservation Act. The gist of accusation in this case is that on
Case 13 is there.
on which date?
1/7.
On 1/7/2025, one Ritik Kashyap, SI of police, had lodged an FIR before the officer in charge of Gosaigaon police station, inter alia, alleging that on receipt of an information through reliable sources that Hotel Bismillah, located in Shimultapu Bajar, is indulging in slaughtering of cattle and selling beef meat in contravention of the provisions of Assam Cattle Preservation Act 2021, and a search was conducted in the said hotel on 1/7/2025. Stop. During search operation, 5 kgs of suspected cooked meat, 5 kgs of cooked meat suspected to be beef was recovered from the said hotel. Learned counsel for the petitioner has submitted that the petitioner is the owner of the hotel and used to sell cooked buffalo meat and not beef as alleged in the FIR. In support of his submission, he has produced a cash memo, produced a tax invoice issued in the name of Buffalo issued in the name of Bismillah Hotel, as well as health certificate wherein it appears, from which it appears that the firm from which the petitioner had purchased meat deals with buffalo meat. Stop. Learned counsel for the petitioner has also submitted that since the meat which is suspected to be beef has already been seized, and since the petitioner, being a lady, has been detained behind the bars for last 21 days, her custodial interrogation may not be any further required. Hence, he prays for allowing the petitioner to go on bail. Learned Additional Public Prosecutor Mr. K.K. Parashar, on the other hand, has produced the case diary of Gosaigaon PS case number 87 of 2025 and has opposed the grant of bail to the petitioner on the ground that sufficient incriminating materials are there in the case diary. He also submits that FSL report in respect of the seized meat is still awaited. Stop. I have considered the submissions made by learned counsel for both the sides and have gone through the case diary of Gosaigaon PS case number 87/2025. Since the suspected beef meat has already been seized and sample thereof has also been sent to the forensic laboratory, and since the petitioner has been detained behind bars for 21 days, this court is of considered opinion that the nature of accusation leveled against the present petitioner. Now, in case nature of accusation leveled against the present petitioner does not justify further custodial interrogation beyond the period for which the petitioner has already been detained for fair completion of the investigation in this case. Stop. In view of the above named petitioner is allowed to be released on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned
SDGM M Gosaigaon.
SDGM M within bracket M Gosaigaon with following conditions, number 1 and number 2. Send back the case diary. This bail application is accordingly disposed of.
Some deep development. Bail hearing item 46. 36 minutes, perhaps case diary is not available. Not available. I am on interview.
36.
earlier one city was the updated city was
Mr. S. Nawaz, learned counsel for the petitioner. Also Mr. K.K. Parashar, who prays for some more time for producing the updated case diary. Prayer is allowed. Let this matter be listed when.
interview after 19 August.
On 19th of August, the interim order shall continue till next day.
37 on the subject submitted.
Here I am on interim bail, Lordship.
Heard Mr. B. Chaudhary, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor, who submits that though the case diary was called for, however, in the meanwhile, charge sheet has been laid, bearing charge sheet number.
116/25, dated 31/3/25.
Stop. Learned counsel for the petitioner has submitted that the petitioner was granted interim anticipatory bail by order dated, yes, which order?
Is a 6/5/2025.
You have appeared?
Yes, Lordship, I have appealed.
6/5/2025, and in pursuant to the directions of this court, he has cooperated in the investigation. In view of the submissions made by learned counsel for the petitioner regarding the cooperation rendered by the petitioner in the investigation, the anticipatory bail, the order dated
6/5/25.
continue. The bail granted to the interim bail granted to the petitioner by order dated 6/5/25 is hereby made absolute with a condition that he shall cooperate in the trial.
Highly obliged. Lordship, I have another clear lordship regarding item 25. Lordship has disposed of this matter, Lordship. After Lordship examination of the three witnesses, Lordship, the petitioner is directed to approach the bail for court below, Lordship. May I pray, Lordship, one time frame may be given, Lordship, in that time that court will. Otherwise, Lordship, they will not complete the investigation.
You come back. And this is a delayed submission.
That part will hopefully, Lordship.
Suppose you make a submission day before yesterday, you forgot to make some submission.
Only because
Can you
of
make it today?
That Lordship, hopefully Lordship has not signed that order, Lordship. That's why Lordship make it such a Lordship. Only time limit, Lordship.
Okay, so something I may look into.
Lordship, item 51 is a very short matter. There is IA for extension of the time of the appearance. Your Lordship granted him, but unfortunately his lawyer, because of cancer, has gone to Calcutta and he lost the mobile also, communication could not be done. And the accused also was in the hospital for more than a month, my lord. That's why he could not appear. Now he wants to, he has approached before the Lordship, my lord, to extend the time, my lord. Today, time not permit, tomorrow, my lord. 51 item.
51, any submission?
51 or 50? 50. 51.
No, 51.
51. CD is not there. No question of CD. Just extension of time. IA is there.
51 Dioksan. By year.
My lord, your Lordship order is page 9, my lord. Kindly see.
Order of?
Yes, that's true. There was direction to appear on 6/3 because the
But
lawyer,
you are appearing now.
well, your Lordship knows that Pushilal, his lawyer, is suffering from, I should not say, my lord. He has been to Calcutta, my lord. He could not communicate. And the accused also lost his mobile from 13/3/25 is in the hospital, my lord. And my lord, his kidney also affected, my lord. I have given all the documentary evidence. He lost the mobile. That also police report also I have annexed, my lord. Kindly give me 7 days time. I will appear with that order, my lord.
Okay, I'll go through the petition. If it can be disposed of, I'll dispose. No, according to you, but if according to me, if it can be disposed of. Otherwise, I will pass some other order. I'll the chamber of Divo.
I'll appear. I want to.
How much time? How much extension?
7 days. If I get the order tomorrow, I'll send it to 7 days.
Okay.
Compare Lordship. Lordship, item number 50, Lordship. Kindly day after tomorrow,
No. Other matters will be left over.
Friday, my lord, 570. My interim order is still today.
Wherever there is interim, interim will be allowed. For other matters, registry will give dates.
Obliged. That is those cases may be, date may be given.
Yes, wherever case diary is there, court master will give date. I am giving him trouble.
Lord.
He is reluctant to take.
Maybe.
Wherever court case diary is there, a specific date is to be given according to our board. And others,
Lordship, it's a revision petition, Lordship, long pending matter, Lordship. Family pay next week on Tuesday.
no, the same thing is applicable to, it is also left over. Yes.
Item number 53. On the last day, 19th of June, I had completed my part of argument, madam. But today again it has come and the delay may disturb the result of the assertion based of the accused, my lord. For the purpose it requires may be highly disputed, my lord. So I pray your lordship, my lord, if possible, on 29th of this month may be fixed for hearing.
Who is for the other side? FKRs. 53. Okay, 53 is on 29. 29.